Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. And thank you so much for coming to spend part of your Monday, February 3rd, 2025 with me. Today, we are supposed to go back to Norfolk County, to Dedham, Norfolk Superior Court in Dedham, to the courtroom of Justice Beverly Cannone for the bench trial of Penny McGee. Here's the thing. Nobody's streaming it live today. Oh, this is interesting. Law and Crime is not streaming it. They were streaming it last week. Today's a really important day for the Penny McGee trial because the medical examiner testifies today. I want to know his cause of death. I want to know whether this argument that Penny McGee had with her ex-husband, Andrew Saviitz, had anything to do with his death. Because if we are prosecuting people for manslaughter in Massachusetts for having a verbal altercation with someone who then dies of a heart attack, it's a slippery slope. And I have the Zoom feed up, but when I called the court to get it, they were like, "Who are you?" And then they said, "Well, we don't know if we're going to turn the Zoom on today." And I said, "But people are very interested in this trial, and it doesn't seem like Law and Crime is going to be streaming it live today." So they said to me, "Well, we don't know if they're going to turn the Zoom on." Sus. Why? Why do we not want the public to hear this? We're trying to get in through. I have the Zoom up. I know someone else who's also waiting on the Zoom. We don't know if they're going to turn it on. Last time they had it on, it was audio only, which is fine with me, but I want to hear it. If you know if there's anybody else who is streaming it. Hi, Mastat. She was quite nice to you. I just called the clerk's office, so I don't know who I spoke to, but they were kind of annoyed. And usually they're very nice over there. But, you know, I'm not disparaging anyone. I would just like them to turn the Zoom feed on so we can listen to it. Because actually, when I went back to watch some of Zuzi, the daughter's testimony, or I was listening to it in the car this morning because Law and Crime put up another about hour-long part of Zuzi's testimony. The white noise in the background, it was like they tried to turn it off and it was insufferable. Court TV doesn't have it. Court TV doesn't have it live. I've checked everything. If anybody else has any other, I don't even know if there's a camera in the courtroom today, because that is what the clerk said to me, that nobody had checked in as far as media who was going to be running camera in the courtroom. So yeah, we have to speak to the manager here. It is strange, super sus, but it's going to be a short day today because it's only going to be the emergency room physician and the medical examiner. But the medical examiner to me is the most important testimony in this case, because the state's or the Commonwealth's most important witness was supposed to be Zuzi, the daughter, who was estranged from her mom, who came in to testify that she testified in court that she saw her mom slapping and punching and shoving her dad before he died of a heart attack, but she never told that to any police. She never told that to Trooper Yuri Buchanan when she gave her statement on January 29th of 2020, which tragically is the same day of the death of Officer John O'Keefe, but this was 2 years earlier. Happened in Brookline. A lot of people don't know that Brookline is part of Norfolk County, but it is. So we'll sit and we'll wait for the Zoom, and I don't know. Court TV is not doing it live. I was on their website and they were talking about some other case that they were covering today. This isn't it. They're right now. It's the Deadly Son murder trial, Florida versus O'Colin Griffith. That's what they're broadcasting live on their website. So there's that. Thank you, BXC, for your 5. Green is your color, Melanie. Oh, thank you. Remember to like and subscribe. Thank you, thank you, thank you. Thank you very much. We have a lot of new members today, so welcome to Paula Sarno. And Dr. Russell is the GOAT. And Ensing 1228. And also Carrie Carter. All 4 new members today. Welcome, welcome, welcome. I think you're going to like it here. So for those of you who are not familiar with this trial, I'll just give you a little recap, catch you up. I think this is our 3rd stream on this trial. The first stream, we went over the entire first part of the trial. And then I think the second stream was live court on, I guess it was Thursday, because what's great about this trial, we're covering it anyway, is that it will never conflict with the Karen Reed trial or Karen Reed pretrial proceedings because it's the same judge. And so when Penny McGee's trial is off, Karen Reed's trial, pretrial stuff is on. And so we don't have any conflicts. So there's that. Good morning. Good morning. Yes. So okay. So back January 29th, 2020. Penny McGee and her husband, Andrew Saviitz, had been divorced for about 6 years. They have 3 children together. And Andrew Saviitz was a politically connected man who had run the 1988 presidential campaign for Michael Dukakis. It's the only connection that I can think of here that would make them really want to prosecute this case. Penelope McGee, who was a Rhode Island socialite, she also had ties to politics. Her parents were both in politics. They say she's a socialite. She doesn't have any money now because she's been appointed a public defender. Larry Tipton is her attorney. I like him. He's also going to be representing Brian Walsh. She went over to his house to have a conversation with him about an email that she received from his brother because she had been evicted from the house that she was living in with her 3 kids. That was owned by a trust run by his brothers, Andrew's brothers. There is some discrepancy as to what happened when she went there, but they got into an argument. Penny's version that she told the police was that he began slamming her against the wall, pushing her, dragging her by her hair. She was trying to leave when he dropped out of a heart attack in the foyer. Zuzi, who was the daughter, she still is the daughter. I'm sorry. She says she was 17 at the time. Some of the news reports says she was 18, but on the stand, she said she was 17. She was a senior in high school. She was estranged from her mother. We don't know why. She was living with her father, and her father and her mother had an arrangement that the mother was allowed to stay at that house with them, but only if Zuzi wasn't there or if Zuzi was in her room and they did not have to cross paths. We don't know why. So Zuzi testified on the stand that her mother was slurring her words and stumbling. But on cross-examination, Larry Tipton got her to admit she had never told anybody that before. And when he said, "Did you ever tell that to police?" She said, "No, my father just died." "Did you ever tell that to Yuri Buchanan when he took your statement that day?" "No, my mind was on other things. My father died." She was very, I wouldn't say she was belligerent, but she's still very angry. And you can see that she's still very angry and she's mad about her father's death. She wants someone to have to pay for it. And she is still very angry with her mother. And I'm sure that she blames her mother for her father's death. This is the problem. The problem is that there may be no causation between this argument that her mom had. And so there was also other cross-examination I don't know what I just said because my mind, I haven't had enough iced coffee yet. On cross-examination, she was also confronted with the fact that she had never told anybody that she had seen her mother hit her father with a closed fist, that she only said that her mother shoved him one time. And that was all she said that she saw. Her testimony also was that she kept running upstairs because her brother Harry was up there. And she says that she told Harry to stay in his room on the stand, but then she told the police that Harry was sleeping. And that initially, she said on the stand, initially she thought her father was fighting with Harry downstairs. She never said that in any of her statements. So there's a lot of conflicting testimony, and Zuzi is the star witness here. Because Penelope McGee or Penny McGee is claiming self-defense, she's going to have to probably, I imagine, get up on the stand unless they move for a directed verdict or a judgment after the close of this Commonwealth's evidence, which is typically done in every criminal case, and the judge grants it. I don't know what the judge is going to do, whether she would grant that motion based on, the testimony. And that's why I want to hear what the medical examiner has today. So I hope Clerk Jim turns on the Zoom because we need to know. We need to know. Why would they bring this? Why would they decide to prosecute her? Unless it was political, unless Andrew Saviitz had political ties, and she wasn't indicted for this manslaughter until more than a year later. She was arrested initially earlier or later in the early morning hours of the next day on what I imagine are domestic assault charges. But we really don't even have any evidence of that. Penny says that he's the one who dragged her around by her hair and slammed her up against the wall in the refrigerator and was mocking her, or, he was teasing her about being evicted. She was also still his healthcare proxy, and they had been divorced for 6 years. They were trying to co-parent together. I don't know if there was any other DV allegations against either one of them prior to this. Haven't heard anything about that. So I'm curious. Where's Melanie Little's left swipe in StreamYard? Your network connection is timed out, or your organization has disabled access to Zoom from the browser. What are you talking about, people? I don't know why they don't want us on the Zoom call. I swipe myself out. Let's retry. Can make me type all this stuff again. Yeah, it was on, except for that it just cut me off. So hang on. Video even, you guys. We even got video. This is going to be wild. Thank you, Clerk Jim. Thank you. Thank you. I wish I could thank Clerk Jim in person.
And then Brendan Owen, that was the second thing.
Yeah, it was three. 3 and 4, sorry.
3 and 4?
Yep.
Oh,
2 is like a.
can't stand being session 2. I like being session 1.
I know.
Just turn it over and it's right there.
Can you guys hear it? Can you hear? Okay, good.
Do you have the next date? No, next date?
Okay, I should be muted.
I may get this.
I have my setting on mute, and sometimes in the courtroom they forget to mute it because, you know, free Billy Tibbetts, free Billy Tibbetts. It's going to be hard because I can't stop and comment because you can't pause the Zoom feed, but here we are. And this is all we got, but it's okay. I'll take notes. I don't know why they had the video on and then they turned it off. It's all right. Like they say in preschool, you get what you get and you don't get upset. Good morning. Does OB have a shirt that says Free Billy Tibbetts? Girl, why didn't you send me one? I want a shirt that says Free Billy Tibbetts. Come on. Patty Paralegal is here. I don't know. Law and Crime is more interested in the ASAP Rocky trial, I guess. I don't know. Well, he had hypertension.
Thank you.
He had a 90% occlusion in one of his coronary arteries. He had had a stroke 6 months prior and 2 major car accidents. They're whispering into the mic. My amazing moderator, Scott, got this for me, Meg. Isn't it awesome? NYPD Detective DEA hat. Oh, I love you too, CPU Mod 1. Thank you. What a nice way to start the morning. Clinton, I wonder if Karen Reed's team is aware that apparently
I meant to get them and I
Judge Cannone, I'm like, he's dropping on there, whispering into the mic. Beverly, Judge Cannone is okay with the DA text sitting amongst attorneys. It just allowed Karen Reed's tech guy to set a trial 1.0. It was the tech person for the prosecution for the Commonwealth that was allowed to sit at their table. I think that happened last time too at Karen Reed's trial, right? Did it? Miss Gilman. Miss Gilman was the tech person for the Commonwealth at the first trial. Was she allowed to sit at the prosecution's bench? I don't know. I think she was sitting there. Thank you, Clinton, for your super chat. Hi, thanks, Little Miss Red Velvet. No, we can't put links in you can't put links in the chat, but thank you. I'm sure if anybody wants to see it, they will go to Microdots. They will find the link for that. I don't know what the t-shirt says, but that's cool. He was a very sick man, Bice. He was a very sick man with a lot of comorbidities, pre-existing conditions, and this is a very, very interesting case. I know I feel like a fly on the wall, too. On a handbasket.
Are we waiting for the judge or your witness?
Oh, no, derp, derp.
Your witness is here.
First of all, thank you for telling me that. I don't know what he did. The joke is that they forgot to turn the Zoom off. That's the only part of the joke. But that R word, we can't really spell that out on YouTube because they have AI that goes through the chat. It's hard to find any information on that Billy Tibbetts case because there's another Billy Tibbetts, apparently. Oh, and now they have the white noise machine on, and that's in my ears right now. I don't know. The Microdots shirts are super cute. They say Team FKR with a heart, black or pink t-shirt. Oh, that's cute. That's cute. All right, you guys, if you want a t-shirt, go look later. Right, there are 2 Billy Tibbetts, so it's an inside joke. I know. Somebody came onto my into my comments yesterday about the Judge Janine stream that I did, because Judge Janine is spewing misinformation on the Karen Reed case, and the thumbnail said, "Judge Janine, you wrong." And those of you who know why it says you wrong. I explained it during the show that it was an inside joke, and explained why. And the person came in and said, "Listen, you might want to correct your thumbnail because, you might want to take it in reverse because verbs are a thing. It should say you are wrong." And I was like, oh man, really? It's amazing to me that people just stop just to write a nasty comment, but having been on these rough streets of YouTube for over a year and a half now, nothing surprises me anymore. How can I mute this? If I take it off. Can you hear that horrible rumbling? All right, listen, I'm going to take it off for now. Can you still hear that horrible rumbling? Or no? I know the grammar police can't help themselves, Magenta, but I am also the grammar police, as you know. Hank Brennan. Hank Brennan spelled his name wrong. Spelled his name wrong on 2 of those motions that we looked at on Friday. Wacky. Okay, you can't hear it? Good. So when it comes back on, then I'll put it back on. I'll just be the one hearing the rumbling because it's wicked annoying. Hi, Olivia. Good morning, Olivia. Olivia, they're not broadcasting this today. It's just the Zoom feed. I have it up, but they have the white noise on, so it's super annoying. We're going to get audio only. I can't pause and talk, but there's only 2 witnesses today, as far as I know, the ER doc and the medical examiner. I'm going to be curious to know if Yuri Buchanek strong-armed the medical examiner into changing her manner of death. I mean, I'm interested to know if the manner of death on the death certificate is even a homicide. Because from what I read, the cause of death is something like cardiovascular disease, hypertension, diabetes, recent stroke after an argument. Kind of like how the medical examiner who did the autopsy of Officer John O'Keefe wrote, injuries do not seem to be consistent with a fight. This is a different medical examiner than in the Karen Reed case. That was Irene Scorti Bello, and this one is, I think her name is Rebecca Dedrick. Yeah, Letter O's by Better O's is here. Exactly. Exactly, Brick Al. I find it strange the addition of after an altercation. I forget if it says after an altercation or after an argument. But we're waiting for them to start and take off the white noise so I can put the Zoom feed back up for you. If anybody finds out in the meantime whether anybody's live streaming the video on YouTube, I do not think they are because the court clerk told me that no one had checked in for media, that they don't even know if there's a camera in there today. Looks like Court TV is covering the ASAP Rocky trial. That's not until the afternoon. They could have done this one too, because this one is, I think, going to be morning only. They're also covering live Monica. No, wait a second. ASAP Rocky. Okay. All rise, please. But please, please, please turn off the white noise. Thanks, Olivia. Dr. Dedrick opined that the cause of death was cardiac dysrhythmia following an altercation in a person with hypertensive and arteriosclerotic cardiovascular disease and diabetes mellitus. Diabetes. And they just muted it. All right, it's muted. We're waiting. Still waiting. Good morning. Good morning to Georgia. Juliana says, good morning from Georgia. I hate it here. Here you mean in the courtroom of Norfolk Superior or in Georgia? There is no jury. This is a bench trial. Judge Cannone will be deciding the fate of Penelope McGee. Why we're so interested. Nope. For those of you just joining, this is going to be Zoom audio only, but at least they turned it on because when I called, they said they weren't going to turn it on. I think a couple of other people called in, so they decided to turn it on. And initially it had some video, but then they turned the video off. So we're just waiting. Ipsy Dixit. Ipsy Dixit. Marilyn says lifestyle choices is the culprit in this case. Yeah. Thanks for hanging around with me for 5 months, Sherilyn. Ipsy Dixit. If you know, you know. Who decides that it's a bench trial? The defendant, Penny, waived her right to a jury trial. So it's her decision to make. It is her decision to make. And she made it right before jury selection was supposed to start, which was last week. Just another manic Monday. Yes, 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 it is. Just another manic Monday. And here we sit. That's where I get it from. The Talking Heads, Misty and Eddie. If you know, you know. If you know, you know. Oh, James, you were going to go to court this morning so I could see you? Well, no, it would have been better if you did go to court because in case the Zoom feed does not work out, you could have reported back about what went on in the courtroom. And there's nobody at this trial. Penny McGee needs support. The courtroom was empty.
All set.
All set.
Don't you?
All set. Jim said that though. Usually the judge says you are all set. No, Judge Janine has not called me. I don't expect that she will.
Judge, this is 21 CR 16, the Commonwealth versus Penelope McGee. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Jennifer Blair for the Commonwealth.
Good morning, Ms. Blair.
Good morning, Your Honor. For the Commonwealth.
Good morning, Mr. McGee. Good morning, Ms. Crawford.
Good morning, Your Honor. Larry Tipton from Ms. McGee, seated to my right.
Good morning, Mr. Tipton. Good morning, Ms. McGee.
Good morning, Your Honor.
All right, Ms. Blair, who is your next witness?
My next witness is Dr. Olufadeji.
Okay.
I can't spell that. This is going to be the emergency room doctor.
I apologize for a late start. I just had to triage for another case.
That's okay, Jim. It's okay about the late start. No worries. No worries. 9:26, we're here. It's not like hours we had to wait. Clerk Jim does a very good job running this courtroom, I have to say. He's got it. He's on top of it. God save the Commonwealth. God save the Commonwealth, David Reese, who keeps changing his name from one name to a better name. Gatling gun dystopian approach. Witnesses being sworn. Dr. Olufadeji. No idea. Yeah, the prosecutor in this case is Jennifer Blair.
Whenever you're ready, Ms. Blair.
Okay, good. Thank you.
Please turn off the
Morning.
Good morning.
State your name.
Ayobami Olufadeji.
Spell your name, please.
First name Ayobami. Last name Olu. F as in Frank. Adeji.
And by whom are you employed?
Beth Israel Deaconess Medical Center.
And what is your position with the Beth Israel Deaconess?
I am an attending emergency physician.
And doctor, can you explain for the court what is your educational?
Yes, so I completed undergraduate training at the University of Maryland, Baltimore County with a bachelor's in biological science. I then went to Dartmouth College, Dartmouth Medical School, where I completed an MD as a medical physician, and then trained at the Harvard Emergency Medicine Resident Program, which is actually at Beth Israel Deaconess as well, and completed training there.
And have any board certifications?
Yes, I am board certified by the American Board of Emergency Medicine.
And how long have you worked for the Beth Israel?
I've worked there now for close to 6 years, but I also trained there as a resident, so a total of 9 years.
The witness is scrolling across the bottom of the screen.
What is your current position?
I'm currently still an attending emergency physician at the Beth Israel Deaconess.
And as an attending physician in the emergency department, what are your duties?
Yeah. So duties there include the practice and care of patients who present to the emergency department. Duties also include the supervision and training of future residents who will go on to be attending physicians. But our work essentially spans all that comes into the emergency department. So treatment of acute illnesses, treatment of trauma cases, and being able to manage and treat in an extensive way.
Drawing your attention back, January 28th of 2020, you were working for the Beth Hospital at that time.
Yes.
And what was your position on January 28th of 2020?
I was an attending physician in the emergency department.
Okay, do you recall what your shift was on that day?
I do not.
At some point on January 28th of 2020, you advocated to treat a in the name of Savitz.
I did.
Explain for the court what happened with regards to Andrew Saviitz on that evening.
Great. If it's okay, I will look through the clinical documentation that I provided on that day. This
Sure.
case was 5 years ago.
Sure you can.
Thank you.
He's now referring to the medical records,
So
and the
it
judges will
appears
let him do
that
it.
on that day, the patient had presented in what we call cardiac arrest.
What is cardiac arrest?
Cardiac arrest means that the heart has stopped working.
And what time did you see?
I, per my notes, evaluated the patient at 11. Yes. We began at 11:46 p.m.
And can you just explain for the court, what was the condition of Mr. Savitz when he lost?
The patient was unresponsive. Per records, we had told that his heart had stopped working a few minutes prior to arrival and had been undergoing CPR at the time. But when he presented to the emergency department, he was in cardiac arrest, and so his heart wasn't working, and he was obtunded.
And what did you do as a result of Mr. Savitz?
So we progressed with what we call advanced cardiac life support, which is a series of procedures and interventions that we take when any patient presents in cardiac arrest.
Which series of procedures? Or on Mr. Savitz?
Excellent. So per documentation here, we initially began with high quality CPR, which had been ongoing per EMS by the time of arrival. We then continued with the usual protocol, which is checking for pulses every 2 minutes and intervening as is necessary. Over the course of my notes here, it appears that we intervened with epinephrine, we intervened with calcium bicarbonate, other medications as per the protocol. And throughout the course of his time in the emergency department, we unfortunately weren't able to get ROSC, which is return of spontaneous circulation. It is return of spontaneous circulation, meaning his heart we were not able to get his heart to beat back in a standard way.
And the medications that were administered, can you explain those medications?
Yes, so I will start actually with the first one, which is epinephrine, which is a medication that is used to restart the heart, usually in cases of cardiac arrest like this. The other medication there that we give is calcium, which is a cardioprotective medication. Essentially is used when you think that there might be other toxins in the body, and calcium protects the heart muscle itself. Another medication there called bicarbonate is a medication that we give when we think that a patient is in something called acidosis, which is something that can develop after a patient has been in cardiac arrest for a while. And then finally, the other medication that I see here is a medication called amiodarone, which is a medication that we give for arrhythmias.
So what are the resuscitative efforts?
Yeah, so in addition to this, we actually also made attempts to cardiovert him. Cardioversion is a procedure by which we put electrodes on a person's heart and try to restart the electricity of the heart.
Could you repeat the name of that?
It's called cardioversion. Cardioversion, correct.
And what were the results of that?
Through all of this, we were unfortunately unable to obtain ROSC, which I mentioned earlier. And so the way that this procedure happens is when a patient presents, there are certain criteria that you're looking for whenever the patient presents. And one of them is to see if they can actually have what we call an organized rhythm of the heart. We were unable to get this. Many of these medications and many of these interventions were to try and see if we could restart the heart functionally.
Is there anything else that you did to try to?
Yes, so we also intubated the patient as well. One of the many things that we have that happens is we have certain protocols by which we go by to think about what the causes of cardiac arrest could be. One of those is if the patient is hypoxic, which means the patient is not getting enough oxygen. We had been informed that the patient had vomited en route to the emergency department. And so as a result of that, we're concerned about the fact that there could have been vomit in his lungs. And so we intervened by intervening, which is where we put a breathing tube down so that we have oxygen directly into the lungs as opposed to using the nose.
That was performed.
That was performed, correct.
Once
Yeah.
he was intubated, what happened?
We intubated him and we continued with CPR.
And what was the result of our after?
The CPR, we were unable to obtain ROSC.
For how long did you continue to work on Mr. Savitz?
Per the documentation here, it appears that we worked on him for approximately 40 minutes.
40 minutes?
That's correct.
And at the end of the 40 minutes, what was the ultimate?
A time of death was called.
What was the time of death?
Time of death was 14 minutes past midnight. 0014.
What the time of death is called? What happened?
So right as we are making the time of death situation, we essentially go through a protocol where we make sure that we have covered all the gamut of what we think is necessary in order to intervene. And at that time, we also take a look at the heart with the machine to make sure that there's no rhythm. At that point, that happened. The patient was unresponsive. His heart wasn't beating, and the time of death was called.
And once the time of death is called, what happens?
So once the time of death is called, we then have a criteria that we use to determine whether or not a medical examiner should be called into the case. Per the record, Mr. Savitz did meet that criteria and the medical examiner was called.
What was the criteria that was met?
So there are a number of different criteria that are used. I'm just going to pull up to here. The one that we had used to decide to call was, just take a look here. I apologize, I did not see that documented, the actual reason for calling the medical examiner.
Oh, interesting.
I've read it, Miss Blair. It was in the records that I read this weekend. So it's in evidence.
The judge did her own homework.
If you have something that you want him to look at, that's fine too.
I don't know, Cynthia, if Andrew Saviitz was a friend of Marcy, but if anybody knows that for sure.
By anybody else?
I did not personally, but it is the protocol of our team to usually do so, using by calling the social worker who then helps to coordinate the care. My pleasure.
Tipton?
Hi,
This will be cross.
good morning.
So would the procedure be that when someone comes into the ER and you begin to attend to them, you and your team, that eventually clothes are removed?
Not in all cases.
You know if they were removed in this
I
case?
do not recall.
Nobody showed up.
And if you do, and I don't know that you will, but do you recognize the name of Nick Giusti?
I do not.
But there is a procedure and policy of Beth Israel that if clothes or items are removed and someone deceased, is it your understanding that the clothes then are transferred to the police or the Mass State Police, whoever is attending to the death?
I do not know that.
Okay. What is pericardial effusion?
Pericardial effusion is when there is a fluid around the heart. That fluid can be from a number of different things. It can be blood, it can be serous fluid, but yes, that is what a pericardial effusion is.
And do you recall, in fact, you saw no pericardial effusion?
Per my documentation, that is correct.
So there was no fluid around his heart?
Not at the time that we obtained the ultrasound.
And did you administer something like a defibrillator at the ER to try to resuscitate?
That's correct.
How many times did you do that?
For the record here, we attempted defibrillation twice in the emergency department.
Twice. And if you know, from what you observed or what you might recall, you know if a defibrillator had been used on Mr. Savitz before he arrived at Beth?
Yes, per the record that we received from EMS, there had been an attempt to defibrillate him before he got to the emergency department.
Can I approach, Your Honor?
Yes.
That's what I thought too, except
Doctor, I'm going to show you.
it's not the right artery. The Widowmaker. Stephanie, that's what I thought.
I do not recall. I do see red markings on what appears to be the left side of the chest. Not necessarily.
I can't hear the
It could be,
question.
but unclear in this case.
And also,
I think he's asking about burns
Yep,
on his
that's
chest. He's
the
showing him
record.
photos.
This is an endotracheal tube. That is correct. He was intubated, as I mentioned earlier.
They put a breathing tube down his throat.
No objection, Your Honor.
Is he's trying to admit something
You
into
don't need to
evidence?
publish that on the screen.
Looking at photos. There had been some testimony earlier about possible burns on the chest from the defibrillator.
Your Honor, I think that this should be exhibit number 65.
That's what Diane just said.
Oh, 65, okay. Because we had pre-marked 63 and 64. So the Commonwealth would move to admit 63 and 64 as,
Oh, okay. If they're pre-marked, they're already exhibits. In fact,
okay.
I took much of them this weekend. All right.
thank you very much.
Follow up, Ms. Blair?
Nothing further, Your Honor.
Okay, thank you very much for your time.
It's my pleasure. Thank you.
That's the end of the first witness. I think there's only going to be 2 witnesses today, and the medical examiner should be coming up next.
If I may go, I have to sitting outside, I think she can come in now.
Sure. Paul can get her. You need to go out and get her yourself, or do I? All right.
Is that the air conditioning? That's so
Why don't I
loud.
see
in my
counsel
ear.
sidebar for just a minute, please?
Sidebar. Why no camera? No media showed up to cover it today. Law and Crime was covering it last week. They have chosen not to for whatever reason today. Maybe there wasn't enough interest in it, but there's over 2,000 of you here who are interested in it, so I do not know. And that is what they told me at the clerk's office this morning. Let's see what Law and Crime is covering today and why they did not feel that they should continue with the Penny McGee trial. Looks like they are covering ASAP Rocky, but not until 1:30, and they're covering Monica Cementilli, but not until 12:30. Maybe they didn't have a crew. Maybe the camera person called in sick. I don't know. Can't explain it, but we're doing the best we can. Then Law and Crime Network has the Colin Griffith trial on. So there's that. We heard from the emergency room doctor who told us that the patient presented in cardiac arrest, meaning that his heart was no longer working, that they gave him epinephrine, calcium. They defibrillated him twice, and he was also defibrillated before he got to the hospital. He presented to the hospital at 11:46 p.m. He was unresponsive. In advanced cardiac arrest, they had EMS had done CPR. He was pronounced dead at 12:14 a.m., January 29th of 2020. On cross, Larry Tipton
So
brought out
Dr.
there was no
Dedrick?
fluid around his heart.
Yes, Commonwealth calls Dr. Rebecca Dedrick.
Dr. Dedrick is the medical examiner who did the autopsy.
And Mr. Tipton, your expert's name, so we make sure she's here as well.
Dr. Beth, Leah Beth.
Can you make sure she's called too, Jim? She gets to come in the call. Oh, great.
Tell us of the efficacy of the court case now here is the truth, the whole truth, nothing but the truth, so help you God.
Being sworn.
Morning, Doctor.
Morning.
Morning.
Please state your name.
My name is Rebecca Dedrick. Dedrick is spelled D-E-D-R-I-C-K.
And what is your occupation?
I'm a forensic pathologist.
And for whom do you work?
I work for the Office of the Chief Medical Examiner for the Commonwealth of Massachusetts.
And how long have you worked for the Office of the Chief Medical Examiner?
Just about 9 years.
Are you a duly licensed physician?
I am.
And how long have you been licensed to practice?
Since 2012.
Please state for the court your educational background.
After college, I went to School for Public Health, where I received my master's in epidemiology. I then attended the University of Massachusetts Medical School for 4 years. I stayed on at UMass and did a 4-year pathology residency in anatomic pathology, at which point I passed the National Anatomic Pathology Board exam. I then started at the Office of the Chief Medical Examiner, where I completed a 1-year subspecialty fellowship in forensic pathology. At the completion of that, I also sat for and passed the Forensic Pathology Board exam.
Doctor, what is forensic pathology?
So pathology in general is the study of disease. Forensic pathology specifically uses post-mortem after death examination to determine the cause and manner of how someone passed away.
How many post-mortem examinations have you performed in your career?
Over 3,000.
And have you testified previously in court regarding your findings?
Yes, I have.
Have you ever been qualified as an expert in court?
Yes.
How many times?
Approximately 40.
Now, could you explain for the court, what is the structure of the Office of the Chief Medical Examiner?
Do you mean the employees or how cases are called in? Could you clarify?
We'll first start with employees and then we'll move on to the cases.
So at the top is our Chief Medical Examiner, Dr. Hull, and then there are approximately 20 staff medical examiners who are forensic pathologists. We also have intake officers, who are the people who receive the cases when they are called in. We also have medical examiner assistants or technicians and medical legal investigators. Does that answer?
And yes, thank you, doctor. And also, in what types of cases are postmortem exams performed?
At our office, it is any time that the situation surrounding the death is unknown, or if it is something suspicious in nature, whether an injury was inflicted by someone else or there was an accident such as a motor vehicle collision or an overdose. So it is typically either an unknown or unwitnessed cause of death or a death that is known to not be natural.
So what is the purpose of the post-mortem exam?
As a medical examiner for the Commonwealth, I am tasked with two things: determining the manner of death, which is a bucket category, and the cause of death, which is the approximate sequence of events that led to a person's death.
And once your postmortem exam is completed, do you complete any type of a certification regarding your findings?
I do.
And what is that?
That is the death certificate.
And what is on a death certificate?
The information that I just said, so manner and cause of death, as well as demographic information about the decedent.
And does the Office of the Chief Medical Examiner have any national accreditation?
It does.
And what are the national accreditations?
It is through the National Association of Medical Examiners.
And is that commonly referred to as NAME?
It is.
And is the office that you work for accredited by NAME?
Yes.
Now, you stated what the purpose of the postmortem exams are. How do you perform a postmortem exam?
So a case is called into our intake office with whatever details are available at the time. That can include sometimes police reports, emergency medical service reports, hospital records. It varies based on the time. If those are available to me when the case is assigned to me, I review those. And then sometimes x-rays are taken before the examination. If those have been taken previously, I review those first. And at that point, I start my external examination. Those always involve photographs being taken and documentation by me on what we call the body diagram of any demographic information, things such as hair color, tattoos, signs of natural disease such as surgical scars, and any signs of injury to a decedent. At this time, also, if a case is suspected to have had somebody else involved in the decedent's death, evidence may be taken, such as hair and nails. And at that point, once all of those pieces are completed, an internal exam may be performed in the case of a full autopsy. So again, all of the internal organs are examined for both natural disease and signs of injury. Once all of that is completed, along with toxicology specimens, including blood, urine, vitreous, then the death certificate is generated. And if a full autopsy is performed, an autopsy report is also generated.
Now, after you've completed a full autopsy, how do you reach a cause of death?
I take all of those pieces that we just discussed and any additional information that may have come in from police investigations, for example, or if medical records came in later. And I review all of that information and to the best of my medical knowledge, I generate that cause and manner of death.
And do you typically discuss with anyone your findings on a death certificate prior to signing off on it?
It varies depending on the case. If it is something more complicated, it gets discussed with my colleagues.
Now, drawing your attention to January 30th of 2020, did you have occasion to perform an autopsy on that day?
I did.
And what was the name of the deceased?
Andrew Saviitz.
And where was the autopsy of Andrew Savitz conducted?
At the Boston office of the Chief Medical Examiner.
And who was present for the autopsy?
Myself. Unfortunately, I would have to look at the documentation of who else was there.
Yuri
You
Buchanan.
can do that. Do you have your documentation with
I
you,
don't
Doctor?
have that piece of information.
Can you help them?
May I approach your Honor?
Yes, this is a bench trial.
Thank you.
The defendant elected for a bench trial.
It's going to take me a moment to find that specific page.
Based on what happened with the Karen Reed jury, I can't say I blame her.
Tipton, is there an objection to
Norfolk
the
County.
doctor having that report on her lap while she testifies, or at the table while she testifies? Okay.
Thank you, Your Honor.
I found the attendance log. Detective Jeff Kotkowski was there. And in addition, the OCME staff includes a medical examiner assistant who would have accompanied me at the time as well.
Now,
Was Kotkowski in
procedure
the
that you
group message
previously
with
discussed about
Proctor
how you review information and then you start
in
with
the
the
Reed case?
outside examination and then you do the internal examination. Is that how you performed this particular autopsy?
Yes,
February 30th.
yes, it was.
And once you finish your autopsy, you create a report of the autopsy.
I do.
And is that the document that you're referencing right now?
I have both the body diagram and also the report of autopsy in front of me. Yes.
So could you please tell the court, did you observe any injuries to the body of Andrew Saviitz on January 30th of 2020?
I did.
And what did you notice?
He had an ecchymosis or a bruise surrounding his left eye. He also had lacerations of the oral mucosa, which means just the inside of his lip. He had an abrasion on his back, and he had abrasions on his right arm and left leg. And by abrasion, I mean a scrape.
could have been when he had his heart attack and fell to the floor.
Were you able to tell how old any of those injuries were?
No.
And why not?
It's difficult to date injuries unless you have multiple similar injuries on a decedent, and then you can kind of place them in a timeline. For example, if someone had 3 different bruises, one of them was more purple and one was more green, you would know that the one that was green was older. However, you couldn't say the green one was from a week ago and the blue one was from an hour ago. So you would need multiple similar injuries in order to date them like that.
And once you make your observations of the injuries, Mr. Savitz, did you record them in your report?
I did.
Now, Dr. Dedrick, were you able to refer to any medical records prior to conducting this autopsy?
Before I was completed with my death certificate, my autopsy report, yes. I do not know if I had all of the medical records before the actual exam. Those often come in throughout the day, or even up to days and weeks after.
And what medical records did you have with regards to Mr. Savitz before you had completed your death certificate?
I had emergency room records from Beth Israel.
Did you have any other information pertaining to Mr. Savitz prior to completing the death certificate?
I did.
What else did you have?
I had the Brookline Police Department report, and I had the Massachusetts State Police report as well.
Now, what information, if any,
What about all of his
did you
prior
learn
medical records?
from the police reports and the medical records that you factored into completing your death certificate?
There were multiple pieces of information. One that was taken from the police reports was the timeline of when he was seen to collapse. There was information relayed to me, again, in those 2 reports, that there had been some sort of argument between Mr. Savitz and I believe his ex-wife that was reported by their daughter to 911. He was witness to collapse during that argument. And so that was one piece of information that led to my conclusions. The other piece was the Beth Israel records indicated that he had EKG changes that were consistent with what is called a STEMI, which is an ST elevation myocardial infarction. It's a type of heart attack. So those 2 pieces of information were key to my decisions.
Now, once you completed the external examination, did you then move on to perform an internal examination?
I did.
And what did you observe during your internal examination?
Mr. Savitz had quite a bit of cardiac disease. Specifically, his heart was enlarged. He had changes to the valves in his heart, so his aortic valve was calcified. His mitral and tricuspid valves were thickened. He also had severe calcification or stenosis of his left anterior descending coronary artery and his right coronary artery, up to about 90% occlusion. So those are two of the three main cardiac coronary arteries. And he also had moderate, up to 60% stenosis of his left circumflex coronary artery.
He was a walking
He also
heart
had
attack.
moderate atherosclerosis of his aorta. He had severe atherosclerosis of the vasculature to his brain. He also had an old infarct in his brain, which again is consistent with that cardiac disease. And he had what we call nephrosclerosis, which is kidney damage, again, indicative of continuous high blood pressure, hypertension. Again, that fits together. He also had evidence of diabetes, which was also recorded in his medical record. His pancreas was fibrotic, meaning that his pancreas did not function the way it was supposed to. And I neglected to mention on the external examination, he also had what is known as a continuous glucose monitor, which is, again, a device that is often used in patients who are diabetic.
Hello, what are we doing here?
Now, doctor, just going back to your cardiac findings, can you explain what the coronary arteries are?
Of course. There are, like I said, three main coronary arteries. So there's the left anterior descending, the left circumflex, and the right coronary artery. Those are the blood supply to the heart itself. So they provide blood flow to the heart to enable it to function.
And when you say a severe 90% stenosis of the left anterior descending and right coronary arteries, can you explain what you mean by that? What is a stenosis?
Is that a widowmaker?
Stenosis means that it's small. So if you picture it like a pipe, for lack of a better analogy, it would be as though a pipe was blocked so that only 10% of the flow could go through that pipe.
And then when you say the left circumflex coronary artery, which artery is that?
It wraps around the left side of the heart. It's another one of the coronary arteries.
And what is the aorta?
The aorta is the main artery throughout the body that provides blood flow to the rest of the body from the heart. So to the organs, to the limbs, etc.
Now, Dr. Dedrick, the external injuries that you described, could any of those external injuries have caused Mr. Savitz's death?
By themselves, no.
Why are we here? Because Zuzi was mad?
Once you were able to conduct your external examination, your internal examination, and you had reviewed all of the provided documentation from both the police department and the hospital, were you able to form an opinion as to the cause of death?
Yes.
And what was your opinion?
Listen.
I signed out the cause of death as cardiac dysrhythmia following an altercation in a person with hypertensive and atherosclerotic cardiovascular disease and diabetes mellitus.
Could you please explain for the court, what does that cause of death mean?
You can break it down into three components.
Come on,
So
man.
cardiac dysrhythmia means that the heart misfired. Other people might use the terms cardiac arrhythmia or cardiac arrest or cardiopulmonary arrest, but it means that his heart misfired in such a way that his heart was not functioning correctly. The second piece, so following an altercation, means that he, again, had a witnessed argument and immediately collapsed during or immediately following that argument. And then the third piece, a person with hypertensive and atherosclerotic cardiovascular disease and diabetes mellitus is referencing that natural disease that was both in the medical record and also seen at the time of autopsy.
Now, you had indicated before that the timing was an important factor in determining your cause of death. Can you explain what about that timing led you to reach this opinion?
Yes. So NAME, the National Guiding Organization for Medical Examiners, sets out guidelines for how to certify deaths. One of the critical components for cases such as this one is that for a person who is in kind of a heightened emotional situation, whether that's an argument or an altercation or something similar, if they are witnessed to collapse or have an arrhythmia, either during that event or immediately after, you cannot ignore that temporality, that timeline.
Wow.
And so were you able to form an opinion based on that information and your observations as to what the manner of death is?
Objection.
For the reasons stated?
Yes.
Sidebar. So I'm going to allow it subject to, after I hear everything.
What was
Okay.
were you able to form an opinion as to the manner of death?
Yes, I did.
And what was that opinion?
Homicide.
Can you
Homicide.
explain what homicide means according to the Office of the Chief Justice?
In this situation, homicide is a medical definition, which means death at the hands of another.
Wow.
And do the NAME guidelines instruct that homicide is an appropriate manner of death in a situation where there is an argument and a close in time death following it?
Yes, they do.
Wow. No, this is the process. Yes, this is the medical examiner who did the autopsy. And Detective Jeffrey Kotkowski was in the room with
Dr.
her.
Dedrick, with regards to what you read in the documentation, the police report, and what you observed about Mr. Savitz during the autopsy, were you able to form an opinion as to who caused Mr. Savitz's death?
Objection.
Yeah, she can't opine as to who caused it. She's not a detective. She's a medical examiner, forensic
In your
pathologist.
medical opinion, would Mr. Savitz have died at that time if not for the argument that had ensued?
Objection.
For the reasons that I allowed earlier, right, same ruling,
What's the ruling?
which is,
Oh, I'm sorry.
the previous ruling, you can answer that.
No, he would not have passed away if not for the circumstances of that day.
Holy mother of everything holy. For the love of the traveling man. He would not have passed away if it wasn't for that argument. Are you going to risk your entire medical career on that? What if he was really fighting with his son, Harry? Like Susie said, she thought he was fighting with Harry. What if he was fighting with his son, Harry? Would you have brought manslaughter charges against his son?
Yes.
This is insane. Welcome to Norfolk County. This is your district attorney.
Recognize this document?
I do, yes.
What is it?
This is a representation, a copy of the death certificate that I signed for this case.
Now, when did you sign this document?
April 24th of 2020.
And Ms. Crawford, could you please see exhibit number 2? Now, Dr. Dedrick, could you just explain for the court the process of certifying a death certificate?
So often at the time of an autopsy, as we have discussed before, the medical examiner is waiting for additional information. So a death certificate generated on the day of an autopsy is marked as manner pending and cause of death pending. As more information comes out, the final cause and manner of death are then determined. The way that it works at my office, at the Office of the Chief Medical Examiner for the Commonwealth, I then fill out an amendment sheet, either digitally or handwritten. It is then given to an administrative assistant who updates the information in the vital records system, the online system. I then go into the online system and digitally sign the death certificate.
Wow. Or were you pressured?
So in this particular case, it was almost 4 months later, correct?
Yes.
Yep.
And is that an unusual time frame or length of time to have a pending certificate turn into a final?
No, the name guidelines would like 90% of death certificates signed out by 90 days. But for cases that involve more components,
More BS?
this is not outside the realm of what is considered normal.
And so the name guidelines speak to the procedure of certifying the death certificate.
Yes.
I'm gonna have to object and ask this.
Okay, cool.
They didn't up the charges till manslaughter, Carrie, until 2021, till about a year after the death certificate was signed. I don't have time to look at this right now, but maybe Olivia, you know. Kotkowski, was he in the group messages with Proctor and Buchanan in the Reed trial where Proctor and Buchanan were saying, we tried to get her to change her cause of death, but she's a whack job and she wouldn't do it. And then another detective said, oh, you should have let me do it, you amateur, or something like that. What's wrong with you, you newbie? You couldn't get her to change her mind? I don't know if that was Kotkowski who said that or if it was Dechiko. Rookie move. Yes, yes, yes. Little cupcake. Yes, rookie move. We're getting there. Rookie move. I don't know if it was Kotkowski who said that or I don't know if it was Dechiko who said that. If he was in the group message, somebody, bat phone, Mr. Tipton, bat phone. Did Detective Kotkowski ever try and convince you to change your cause of death from undetermined to homicide? Or I'm sorry, manner of death? For those of you who don't know, there's 5 options for manner of death. Homicide, suicide, accidental, natural, and undetermined. John O'Keefe's cause of death manner of death was undetermined. They tried to strong arm the medical examiner to change it to homicide. She never did, and she still hasn't. In this case, it was undetermined at first, and then 4 months post-autopsy, she changed it to homicide. It was Dechiko. Wasn't Kotkowski on but Kotkowski was in the group, right? This is mind-numbing because Trooper Pacheco, I don't remember that name, does not ring a bell with me. Undetermined is what this should be, or natural. It was a walking time bomb. It was the nudes conversation.
So Dr. Dedrick, I'll just ask again, we were discussing changes to the death certificate.
Yes.
And is 4 months an inordinate time frame for a death certificate to be changed?
No, that's typical. But I also wanted to clarify, it was only 3 months for this case. It was January 30th to the end of April. So that is only 3 months.
Slightly more than.
Like 90 days. No.
I'm sorry?
It was just slightly more than the 90 days.
No.
Right.
It's slightly less.
Just under, I believe.
424.
Just under.
January 30 to
And,
424. Do the math.
The name guidelines that you're referring to, they do indicate that a death certificate, it's typical for a death certificate to be changed as more information comes to light, correct?
Yes.
That's what I want to know, Robin. I doubt it. I doubt if in the same circumstances, Zizzy or her brother would have been charged.
Dr. Dedrick, you had indicated that Mr. Savitz's heart had misfired. Could you explain for the court just what you meant by that and what was happening to Mr. Savitz's heart while he was having this reaction to the altercation?
So the information that was provided to me from the emergency room records indicated that he went in and out of what is known as ventricular fibrillation. And that is when, so the heart has 4 chambers. There are 2 ventricles and 2 atria. And the ventricles are what push blood outwards. Out of the heart. And so for him, in the arrhythmia, in the misfiring of the heart with the ventricular fibrillation, it means that the heart is not pumping effectively. It is moving in a way that is not pumping blood effectively out of the heart.
He was 66.
And can you explain what the fight or flight response is?
Fight or flight is when an individual has a perceived risk, whether that risk is real or, again, perceived given a situation. There's activation of the sympathetic nervous system by a series of different hormones, including epinephrine, cortisol, and that preps the body to be able to either fight, stay, and deal with whatever the aggression is, or flight so that they can flee whatever the situation is. Those hormones increase heart rate, they increase breathing rate so that your body gets more oxygen, they increase blood pressure. All of these components are making it so that the body can deal with that, whatever that situation is. So they can either, the individual can either stay and deal with the situation, or they can run away and escape from the situation.
And do you have an opinion as to whether Mr. Savitz was experiencing this fight or flight response?
It's going along the bottom.
That's insane, unless you can build a foundation.
Fight or
Well,
flight
did
is
you read any information in any of the documentation that you received indicating any type of an event that would have triggered a fight or flight response in a person?
Yes, again, the 2 police reports.
Yes. Renew my objection.
Yes, the objection sustained.
fight or flight is what everyone in Massachusetts should be feeling right now. It's the response that everyone who lives in Massachusetts should be having. Fight or flight. Get the duck out of Massachusetts.
If a person had a 90% stenosis in their carotid artery, would that condition cause their body to respond differently to a fight or flight response?
I'm going to see you at sidebar for just a minute.
Sidebar. Their claim is that because Penny knew of his medical conditions and she was on notice of his medical conditions, like his 90% stenosis and blockage in, I think she said, 2 of his coronary arteries, in addition to his diabetes and his stroke that he had had 6 months prior. She didn't even bring up the fact that he was in 2 major car accidents, but she did say that the police reports from the night in question did influence her manner and cause of death, which is wild to me. Welcome to the Upside Down. Members, we have special emojis for members. Please give me some Twilight Zone emojis. Twilight Zone emojis. This is scary. What if it was one of the kids? Would they have charged one of the kids with arguing with their dad for manslaughter? She's facing up to 20 years in prison, my friends, and it's self-defense, so she has to testify because she's going to have to testify about what happened during this argument, that he pulled her by the hair, that he slammed her up against the wall in the refrigerator and the stove, that he had been verbally assaulting her as well and physically assaulting her. The medical examiner did say that he had some bruising, but that could have been from when he collapsed and had his heart attack. the inside of his lip. He could have bit his lip when he fell. He could have bit his lip when he was intubated. This is insane. I'm not surprised that there's no cameras in there today because nobody wants the people of Norfolk County to hear this. Wow. And then she had the audacity to say, but for the argument, he would not have died that day. What? How can you possibly make that your medical opinion with a reasonable degree of medical certainty that but for that argument, he would not have died that day? And she's trying to show causation. She, Jennifer Blair, the assistant district attorney, is trying to show causation through this witness. And that is what this witness testified to. And that is wild. How would she know that? Exactly. If he was on blood thinners, he also would obviously bruise easily, more easily. He had hypertension, severe hypertension. Reed says it's like Norfolk County has been taken over by an alternate universe. It's like watching that old show, The Twilight Zone. No camera today? No camera today. Nobody showed up. Nobody thought it was important for you to hear this. So I had to call into the Zoom. Thank you, Linda, for gifting a membership. Alan, Alien Vision, 40. Thanks for the 5. Wonder if the medical examiner will state which word used during the argument was the murder weapon. Yeah. Thanks for bringing awareness to this case. Thank you. Thank you for watching. This is an important case. Share it out. Share it out. I don't know that any other YouTubers are covering it because Law and Crime even dropped it today. So there's that. Good morning, Lady Zelda Kelly. This is like a legal dementia case, in my opinion. Impossible to tell when it starts. Yep. This is it for if you're ever confused about who's testifying. I do have it scrolling along the bottom of the screen. I know it's hard to read if you're on your phone, but this is Dr. Rebecca Dedrick, the medical examiner, the state medical examiner who did the autopsy of Andrew Saviitz. We'll come back to that, sons. Thank you, Nicole Lee, for your super chat and for saying I'm your favorite. Christine says I'm on blood thinners. You bruise all the time. Thank you. Super chat.
Can you tell me what happens in a person if they have a flood of hormones in their body?
A flood of hormones?
Well, it depends on the hormones. In reference to that concept of fight or flight, they are hormones that are activating the body to be able to, as we said before, deal with an aggressor or run away. So that is epinephrine, cortisol, similar. That increases heart rate. It increases blood pressure.
Epinephrine.
It increases oxygenation through an increased respiratory rate. All of those pieces are making it so that the individual can respond quickly.
Now, is it possible for the body to respond in the manner that you just talked about? Increased heart rate, increased blood pressure, flood of hormones. Is it possible for the body to respond in that way from just a verbal exchange?
Yes.
Another person?
Yes.
And do the name guidelines speak to that concept?
Yes, they do.
What does the name guidelines say about verbal altercations?
I won't be able to quote it, but to paraphrase, it is exactly as we said. There needs to be a perceived risk to the decedent, to the other person. It is perception of fear or intent for harm or intent for death. So if that happens during simply a verbal discussion that elevates an emotional response, that is something that can happen, yes.
So it doesn't matter if she touched him or not?
Do the name guidelines speak to timing in regards to the verbal altercation and the body's response to it?
Yes, that
What do the name guidelines say?
timeline needs to be either immediate during that verbal discussion or immediately after.
And what do the name guidelines guide you to find as a manner of death if that temporal connection is there?
Objection.
Ask the question a little bit differently.
When there is simply a verbal incident and there is a close in time death to that incident where the body has experienced high blood pressure, increased heart rate, flood of hormones, what does the name guidelines indicate that type of a death should be classified as?
Objection to the word should.
Objection to the word should.
Question a little bit.
What could you classify that type of a death as?
The manner of death would be homicide.
Because of a verbal altercation close in time to a heart attack. Lady Zelda
Now,
Kelly,
do the name
pull out the tarot
guidelines
cards.
speak to that same situation where the flood of hormones happens in the body, the increased heart rate, the increased blood pressure, but there is a physical assault?
I'm sorry, are you asking the name guidelines deal with that situation?
Yes.
Yes, they do.
And what does the name guidelines indicate you could find as a classification for the manner of death in that situation?
Just asking for, oh, I'm sorry, objection. Just asking for citations.
Objection.
Right?
Do you have the name guidelines with you, Ms. Blair? Do you know the specific citation?
Do you have the name guidelines with you, she said?
I have page numbers written down elsewhere, but they are in that document.
Can I direct her to it or approach?
Yes.
Name is the National Association of Medical Examiners. She's trying to defend her decision to change this to a homicide from undetermined based on the guidelines of the National Association of Medical Examiners. Yeah, why isn't this national news?
Dr. Kennedy,
Great question, Robin.
Yes, this is consistent with what we just discussed.
So just paragraph 28 indicates that if there is a minor injury and then a collapse and a death, that could be classified as a homicide?
Yes.
A civil case? Maybe. The eggshell plaintiff rule would apply in a civil case.
13, paragraph
This is insanity. Sydney says Bev playing God is terrifying. Wow. Just wow. Murder by argument.
That's one here, sure.
And a dozen or so comorbidities, right? MCAT's going to stop yelling at her husband. She's trying to back up her opinion by weaponizing the name guidelines. Maybe she was strong-armed into it and she had to defend herself. And so she looked them up and was like, oh yeah, the guidelines say that if there's a verbal altercation, even if it's verbal and the person doesn't touch the decedent, that even if there's a verbal altercation close in time to the heart attack, we can then rule this a homicide. Wow, just when you thought this trial wasn't going to get any wackier, here we are. Thank you, Literos by Betteros. See how I pick my cases? I pick my cases because I think they're interesting, and I try and give a voice to these defendants
Dr. Dedrick, we just
or victims, depending on the
explained,
case.
Or we just went over
That nobody's talking
paragraph
about.
28 of the name guidelines. In this particular case, did you have information that there was something more than a verbal altercation when you were considering your cause of death?
Yes.
And what was that?
Twofold. One, the police reports indicated that there might have been a physical component. And two, as we discussed before, there were external blunt force injuries, although I cannot commit to when those injuries were sustained.
Okay, that's hypothetical and not clear. Blunt force injuries,
And
but
in
I don't
fact,
know when they
you
were
did notice
occurred.
that there were lacerations
Maybe when he fell.
In the mouth.
Yes.
And
From
so those
being
have been
intubated.
caused by any one of the times they were intubating?
They could have been, but that is an unusual finding during intubation.
Really? Could he
Now,
have
you
bitten the
mentioned
inside of his
that,
mouth when he
you had
fell?
seen Beth Israel records. Can you recall when you got them?
No.
Did you receive any other medical records besides the Beth Israel records?
No. I had 2 sets of Beth Israel records.
Did you see anything in the medical record from Beth Israel that was consistent with an increase of hormones in Mr. Savitz?
Could you ask that in a different way? I'm not sure what you mean.
Was there anything in the medical records that you saw that indicated a response to an exciting event that we were just discussing? Anything like a flood of hormones, an increased heart rate, or a high blood pressure?
Oh, I'm sorry, I misunderstood. Yes.
What was it?
So 2 separate pieces. One was the description that the decedent had been in ventricular fibrillation, then he became asystolic, which means that his heart essentially stopped. There was then a return of spontaneous circulation, also known as ROSC, and then he went into ventricular fibrillation again, and then ultimately was asystolic, no longer had a heart rate. So that is one piece. He had differing rhythms. The other piece was that an EKG was performed, an electrocardiogram was performed, indicating an acute myocardial infarction, so that he had a heart attack. During that short interval.
And
The defense's expert is here today.
Short interval, which short interval?
So the way that it was seen was that it was sustained sometime around when the argument happened.
Wow. I don't know. This is a very difficult decision about whether or not to go with a jury. We've seen what juries in Norfolk County, the jury in Norfolk County for Karen Reed couldn't even determine that John O'Keefe was not hit by a car.
Strike the answer? Yeah, so the question was proper. Ask the question again. I'm going to strike that.
Right. Why didn't she have all his prior
You just
medical records?
testified that he had a heart attack during that short interval. Can you explain what you mean by a short interval? If you know maybe from what time of night to what time of night?
I am unable to give exact hours. However, the fact that it was seen on electrocardiogram but was not seen grossly at the time of autopsy means that the heart attack had to have been sustained within about 12 hours.
And why is that 12-hour number significant?
That's a textbook piece of information from anatomic pathology that you can see heart attacks grossly, meaning in the tissue, at approximately 12 hours.
Yes. Yes, Melissa. I'll star this for later. Thank you, Chloe Albert. Just confirmed.
And Mr. Savitz, you could not see it.
Correct.
Newt's conversation was definitely DeChico and Kikowski. You're welcome. Thank you, Chloe Albert.
Doctor, I have
You might have one. Do you need to speak? Why don't you talk with Mr. McGee?
Oh, sweetie, no.
Dr. Dedrick, what time did you see Mr. Savitz? What time were you conducting this?
The autopsy began at 10:46 a.m. on January 30th, 2020.
Thank you.
12 hours before would have been
Examination?
on the 30th.
Sure.
Would have been 10:46 a.m. That was on the 30th. 12 hours before that would have been 10:46 p.m. on the 29th. This altercation happened on the 28th. He died at 12 a.m. on the 29th. So that's not within the 12-hour time frame, right? Am I doing the math properly? Is my math? Where's Yuri's math teacher? He was pronounced at something like 12:15 a.m. on January 29th. Yes, the sidebars are happening because there's no jury, even because they're just observers in the courtroom, because there are people on Zoom, because most days during this trial, or maybe some of the days, or maybe only one day, there was an actual camera covering this live. He died shortly after midnight on the 29th for baby mama. Correct. Thank you. My math is mathin'. Mm-hmm. Okay. I think what she's saying, Elle says, is that after 12 hours, you start to see evidence of a heart attack in tissue, but this trial is garbage. She's a death whisperer. Yeah. Thank you, Mark McKay, for becoming a new member. Lighthouse Life Coach, thanks for the 5, says, don't die in Massachusetts. Unapologetically authentic, was Marcy responsible for bringing this case? Yes, 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 he was. He's been the district attorney since 2010. This is 2020. Sons 107, thanks for the 5. I live in Norfolk County. From this day forward, I will never argue with anyone again. I can wind up in jail. Oh my, I have no words for this. People need to know. It is snowing though. Thank you for your super chat. This is a witch trial. It's just like Alison Device from UK 1612. Man had a stroke just after he'd spoken crossly with her. She was hung as a witch. You know what? I may have to go back to 1612 and cover this trial. Thank you so much for bringing that to my attention. The 1612 persecution of Allison, is that the correct spelling of her name? Device. This is witchcraft. Because that's exactly such an amazing analogy. Thank you. In the UK. BZ would this apply to healthcare providers? Meaning, if a healthcare provider had an argument with a patient that killed them? I'm not sure what your question means, but thank you for your super chat. Dr. Russell is a goat, says, this is wild. Is this the same Emmy that did John O'Keefe? No. This Emmy's name is scrolling along the bottom. It is Dr. Rebecca Dedrick. The Emmy who did the autopsy of John O'Keefe was Dr. Irene Scordy Bello. I'll never forget that name. Oh, Sarah and Shock and Horror gifting 10 memberships. Not only she is an amazing moderator for this channel, she's an amazing human, so kind and generous, and she did do the 24-hour standout for Officer John O'Keefe in Canton. So props to Sarah and Shock and Horror. She's amazing. I know you love her as much as I do, as much as I love my other moderators. Team Brittany, Lil Cupcake, Scott, I don't know if you're here this morning. Amanda, thank you for your super sticker. Sons 107, thanks for the 5. I'm confused how this is a murder. Well, it's manslaughter, but again, manslaughter, death caused by another, facing up to 20 years in prison. If you argue with someone and they die during it, you're at fault. Well, according to this medical examiner who looked at the National Association of Medical Examiners guidelines, there is somewhere in there, in the guidelines, I'm looking at the guidelines now. Hopefully I can find it for you. I don't know what page they said it was on. If anybody remembers, let me know. I've got the guidelines up. If there is an argument that is close in time to a death, you can apparently classify that as a homicide, she's saying. According to the National Association of Medical Examiners, Sons 107, you are not the only one confused. We are all confused about how this case could have possibly been brought, except the only thing that I can think of is that Andrew Saviitz was well connected politically, having run the Michael Dukakis presidential campaign all the way back in 1988. Some people may remember that. Some people may not have been born until after 1988, but it's curious. I really don't think that a 17 or 18-year-old Susie Savitz could have strong-armed the Norfolk County District Attorney Michael Morrissey into bringing these charges against her mother. But at this point, I guess anything is possible. Thank you, Laura, for the 5. UNOB can have a show called Will the Real Billy Tibbetts Please Stand Up? By the way, blue and green together make your eyes pop beautifully. Oh, thank you. Thank you so much. Olivia, great question. If a jury can't do outside research on the case, how is it appropriate for the judge on a bench trial to do? Well, it's actually in the court record. So those records are in the court file. That's why she has access to them. It would not be appropriate for her to go outside the court file to review anything, but because she said these were a part of the court record, she is permitted in a bench trial to look at them. But that is a great question. Ipsy Dixit again. How is this not a natural passing given his medical history? What's next? We're back in 1612, my friends. We are back in 1612 for that case that amazing viewer just told me about, of Allison Device having an argument with a man who had a heart attack, and then they hung her in town square as a witch. Remember, this is the home of the Salem witch trial movement persecution. Tamara says, so he had a STEMI and years of damage to his cardiovascular system, including major vessels, 60 to 90%. The microvessels in his kidneys, etc., were shot from years of HTN, DM, etc. What the duck? Right there with you. Prayers up for Kooky Carolinian, whose sailor hubby is at sea. She hasn't heard from him since yesterday.
Good morning.
Prayers up. Here's Cross.
I'm going to start with an easy question. You told us that you conducted approximately 3,000 autopsies.
A postmortem examination.
What's the difference?
When you testified at the grand jury on February 4th, 2021, you were asked how many autopsies you had conducted.
Correct.
That is the name, or just...
So they're different numbers. Since the COVID pandemic, we have done more external view type cases and chart review type cases. And for me personally, I actually did a year where I was working I was helping with the telepathology service as well. So postmortem examinations includes all of those types of cases.
So between February of 2021, you did approximately 2,000?
No. I'm sorry. Those are two different numbers. So postmortem examinations include all of those cases. And that's my career kind of starting with residency.
Let me just...
He needs to find the mic. If I can repeat the question to you, I will, but there's not a lot that I can do, I know.
To what you have referred to as the guidelines.
Yes, the name classification guidelines.
And it's, what you're talking about is a document entitled A Guide for the Manner of Death Classification, correct?
Yes.
And I'm going to show you that document first.
Yes.
That's the document.
I have it pulled up.
Yes.
He does like to walk around.
No, Your Honor.
Yes, Melissa, yes, it just might be a third world
Is going to need that.
country.
Probably. You would agree with me, Dr. Dedrick, wouldn't you, that, and I'm quoting from page 2, paragraph 3,
Give me one moment.
Tell me when you're ready.
Yes? Mm-hmm.
Oh, this is good.
The authors of this state specifically, this is a guide, correct?
Yes.
The recommendations contained herein are not standard, correct?
Yes.
And should not be used to evaluate the performance of a given certifier in a given case.
Yes.
So when you refer to them as guidelines, the authors themselves say that they shouldn't be used as standards, correct?
That's what it says.
Yes.
Okay, so they aren't standards, are they?
No, but they are a guide for medical examiners in the United States.
And it's fair to say, isn't it, that in conducting your autopsy, forming your opinion as to manner of death in this case, that aside from your experience and training, this is the only so-called guideline?
No.
You said these are the only guidelines aside from your experience
Were
and
you
training. She
ever
said no.
asked by the Commonwealth to produce all guidelines, protocols, or policies that you relied on to reach your conclusions in this case?
Was I personally asked that? No, I do not recall.
So there are other policies and protocols that you relied on in reaching specifically the manner of death opinion in this case?
For this case, as with any similar case, one of the things that we do at the Office of the Chief Medical Examiner for the Commonwealth, the Office of the Chief Medical Examiner for the Commonwealth, is to discuss cases with our colleagues who have similar training, which is what was done in this situation.
How about the state troopers?
I'm asking you a question. Are there other policies and protocols, written policies?
He wants written policies and protocols that she used, not discussions with your colleagues.
No.
Nope. Put some nope emojis in the chat.
You testified on direct examination part of what the case. Yes, correct?
Yes, I did.
Yes. God doesn't change this so-called heart attack by homicide.
No, this is a guideline for manner of death for all types of cases.
He asked if it was about heart attacks.
Paragraph in this policy only reference specifically to the only reference specific so-called homicide by homicide.
In this guide, that paragraph deals with it, but this is also a summation of research that has been done by other forensic pathologists.
Research that's been done on homicide by homicide.
Yes.
On heart attacks. He's asking specifically about heart attacks.
Laid out in what you just said.
This is a guide that was generated by the national organization as a summary of situations that medical examiners can encounter. There is not a direct citation here that references that, no.
Heart attacks. Reference heart attacks. She's getting defensive.
You were not asked on your examination case about what this paragraph 28 relationship to the mental state of the person involved in either a verbal assault or physical.
They're talking about paragraph 28, which we will look at after this.
The mental state? No, I was not.
And in fact, even in the sparse words in this guide, it's clear, isn't it, that we're not talking about someone who's innocent without any criminal intent whatsoever, had a verbal argument with someone, and then they could be charged with homicide. Okay? That's not what this paragraph is.
He's talking about criminal intent, and it doesn't say that in your paragraph 28.
No.
Right?
In fact, you just referenced other research and their articles. regarding heart attack by homicide. And it's clear, isn't it, based on your recollection of that relevant literature, that there has to be a finding that the person who in fact engaged in the verbal altercation or in a physical altercation had an intent to do harm, correct?
No, I did not say that.
But it's fact, is it?
Fact how?
Fact how?
I don't understand what you're
He's
asking.
saying there has to be criminal intent for you to find a homicide in a case of a verbal altercation.
That to
She's fighting.
teach a manner of death, of heart attack by homicide, or as you put it, death resulting after an altercation of a person. You're saying that that person responsible.
Yes.
And at page 13, paragraph 28, the very first sentence says, death resulting from fear or fright induced by verbal assaults, threats of physical harm, or through acts aggression intended to instill fear or fright may classify as homicide.
May be classified as homicide.
There has to be an element that the person intended to instill fear or fright, correct?
There are other references that are not.
So can you answer that question?
That is what it says here. Yes.
And this is the only thing you relied on, correct?
No. This is a summation of research that is previously done, that is documented in the forensic science literature. This is a summation of that literature. The other literature indicates that it is perception of fear in an emotional state.
My question to you is, you say you're familiar with the literature, correct?
Yes.
The literature, and I'm talking about the literature specific to this thing called homicide by arteries, correct?
Yes.
So you must be familiar with Dr. Davis' 1978 literature, correct?
Dr.
I have read that paper.
1978
And
literature.
his 5 factors with regards to this so-called homicide by arteries.
Homicide by argument.
And you must be familiar then with Dr. Turner's paper dated 2004, correct?
The update, yes.
And he also talks about Dr. Davis's and Dr. Turner's thesis, the quote, strict criteria that must be applied before you can reach an opinion as to manner of death in a heart attack by homicide by homicide, right?
Yes.
And so, do you know what those, what is the first factor that Dr. Davis said is on?
I don't have it in front of me, therefore I wouldn't want to try and quote it. If you have a copy, I'm happy to reference it.
Oh, he did his homework, Larry Tipton. That's the defense attorney. He's assigned
But of
counsel.
note, that first guideline.
Just a minute.
Just a minute. There's no question pending. Thank you, doctor. He's referencing 2 peer-reviewed articles. I imagine they're peer-reviewed that talk about homicide by argument.
I do recognize this. This is the Davis 1978 article.
And
Yes. So we'll mark it for identification.
Let me see the papers so I can answer correctly. It's a McCabeism. Well done, OnlyFans.
what is the first, what is the first criteria Dr. Davis lays out?
On page 386 of the article, the first one is, the criminal act should be of such severity and have sufficient elements of intent to kill or maim, either in fact or by statute, so as to lead logically to a charge of homicide in the event that physical injury had ensued.
Case dismissed.
So the first thing Dr. Davis points out is that there has to be a criminal act involved.
Criminal act.
With the intent to kill or maim.
First thing he points out is there has to be a criminal act. Right?
The first part of the line says that, yes.
Then it says, and it should be of such severity, correct?
Yes.
And have sufficient elements of intent to kill or maim.
Yes.
And so, before you can reach an opinion based on the relevant literature and the so-called guidelines, you have to make a determination that the act that precipitated the rush of hormones be criminal, correct?
No, because the updated version of this article that came out later altered that first point.
Are you talking about the Turner?
I believe it is Turner, yes.
And that's 2004?
Yes.
How did it alter?
I would need to see the exact documentation. If you have it, please.
2004, because she just testified they changed it.
Have you discussed this, as I'm looking for it, have you discussed this literature with the Commonwealth prior to your testimony?
I have not, just that it existed.
What do you mean, you discussed it as existed?
The articles existed, but nothing of none of the content was discussed.
Keyword, intent. And it says severity. A criminal act with such severity that it caused the intent to kill or maim the person. Jesse Pink, you would think.
Thank you. Yes, it is.
Introduce or identification?
Mark it, let the judge have the article.
Introduce the previous.
If it helps you. We've entered the matrix.
Is there an objection?
No, Your Honor.
That's what we want to know, Michael. Did homicide investigators influence her decision? It was Detective Kakowski who was in the nudes conversation with Proctor.
Diane, first of all. Are we having the next exhibitor? Hold on one. That's in the exhibit as well.
No, I do. You gave me the original.
I'll take both of those by you.
So Turner's first step.
Could you wait one?
He says, so now he's moving on to the 2004 article by Dr. Turner, and he says, by Turner's first factor,
What page are you on?
page 2.
And this was where. Dr. Dedrick, Dr. Turner, this particular literature, states as the first factor, the action of the perpetrator toward the victim should be of such severity and has sufficient elements of intent, frighten, injure, or kill. That's how that starts off, right?
Yes, that's correct.
So what's the substantive change that?
What's the
The
substantive
original
change?
version says criminal act, and then the change says actions of the perpetrator. It no longer indicates specifically a criminal action.
But it does say, doesn't it, what I just read to you? An
Such
intent
severity.
to frighten, injure, or kill.
Yes.
So you have to consider the intent of the so-called perpetrator before you can reach a manner of death, such as in this case.
Yes.
Excellent, excellent cross.
And just to be clear, Dr. Davis' paper in 1978 was primarily, clearly, dealing with, quote, only verbal assault, correct?
Yes.
And the modification, the revisited, as Dr. Turner puts in his title, that has to do with he has changed some of the language because now he, as his article lays out, is addressing the factors to a physical touching, correct?
Verbal and or physical, yes.
Now, so you do agree with me that whether you're reading Dr. Davis' 1978 literature or Dr. Turner's 2004 literature, the intent of the perpetrator must be considered, correct?
Yes.
And that intent is to frighten, injure, or kill.
Yes.
Frighten, injure, or kill. Intent must be considered before you can rule it a homicide.
Both Dr. Davis and Dr. Turner in factor number 2 require, before you can reach a manner of death, such as in this case, that, quote, the victim should have realized that the threat to personal safety was implicit, correct?
Yes.
Now, I just read the second criteria flowing from Dr. Turner's article. What is the second criteria framed in Dr. Davis? And it's on that same page, page 2, it's in the body of.
So number 2 from Dr. Davis was the victim should have realized that the threat to personal safety was implicit. A logical corollary would be a feared, threatening act against a loved one or friend.
Feared threat.
Right, not intent to annoy or anger.
To reach your conclusion as a manner of death in this case, you said you relied on the police report.
Yes.
And when you relied on what was in the police report, you mentioned specifically on direct examination that you relied on something that, quote, what the daughter said.
She relied on the police reports. He wants to know what the daughter said in the police reports that she
You would
relied
agree
on.
with me that if two people engage in a physical altercation and a person simply is exercising self-defense without any intent to place someone in fear, harm, or to kill, that not result in manner of death such as
He's talking about self-defense. That would not result in a manner of death,
No.
such as this.
If the way that it was described to me in the police reports did not give any indication of self-defense.
Oh, now you're a legal scholar too. Because Penny's statement was that she was being dragged around by her hair. Did you read her statement?
having said that.
Good.
Forget
Maybe
about the police reports for a minute.
he's going to
Would
whip.
agree that if someone is exercising self-defense, and only self-defense, that even if the person they're defending themselves against collapses and dies, you cannot have a manner of death opinion of homicide by arson.
No, I disagree with that.
You disagree with that
Because the way that this is laid out, again, with the name guidelines and in the literature, is that if there are two people involved, the two people, it is their perceived emotional situation.
How can she perceive their
Either one
emotional
of
situation?
them, if one of them passes away,
She's psychic?
it is still death at the hands of another, thereby a homicide.
Wow.
So you mean that if two people engage in a physical altercation and one person who attacks the other person and the other person simply exercise self-defense, that you would still find it homicide by heart attack and blame that person for the death of that person they were defending themselves against?
Yes.
Wow.
So
She
that
just
kind of
lost.
flies in the face, doesn't it?
No. Homicide
Let me
is,
finish the question, I'm sorry. Fine, Bill.
Even if it was self-defense, she would still find it to be a homicide.
If someone is defending themselves, Dr. Dedrick, they don't have the intent to harm, cause fear, or to kill.
it is the perceived harm to the victim.
How can
The
you
perception of fear or injury or maim. It is not entirely the intent.
How do you know what
So
a
if the victim perceives fear, then it falls in the same
He's dead.
category.
How do you know what he
Homicide is
perceived?
a medical definition, not a legal definition when used here.
You understand?
No.
We understand that when you use the term homicide, that is referred to in the context of the medical examiner's opinion, that the use of the term homicide is a quote neutral term.
I haven't used the term neutral, but it is a medical definition used by medical examiners. Yes.
Homicide is a medical definition.
So you're, in reaching your manner of death, in this case, then you are then making an assumption that the deceased perceives fear.
Right. She's making an assumption about what the
Yes.
decedent perceived.
You base that on the police.
Yes. And the timeline.
So she relied on the police in the timeline.
The timeline of when the decedent collapsed in relation to the information that was laid out in the police reports.
The timeline with your assessment that the person replaces.
Yes.
The thought police.
I'm sorry? Again, the police reports and then the medical records.
Did you have any
There is a
conversations with the detective?
timeline laid out.
No. I understand that. Yeah, I'm sorry. I'm asking you a very specific question. The timeline, just the timeline. How does the timeline inform you that the person who is deceased felt fear?
As laid out in the literature, there's a concept in forensic medicine, but for, which means that had the event or the situation leading to death not occurred, would the person be deceased? In this situation, we have to take the events of that evening into consideration in order to come to the conclusion with the cause and manner of death. And as we've established, the manner of death, as we said, is the intent or perceived intent for to be frightened, injured, maimed, killed.
So he thought,
Therefore, the timeline is critical to determining this cause and manner of death.
I have no words.
The description you give in the report about hormone touching or overpowering someone's heart those same hormones can rush and cause
He's talking about the hormones now. Can't those same hormones rush and cause the heart?
someone to think.
Yes.
So fear involved in that.
Somebody's perceived emotional state. It's impossible to say if somebody being frightened or somebody being angry.
It's impossible to say.
That is very subjective.
Right.
But all of those pieces kind of fit together into the same situation.
Yeah, but if someone gets angry, and it's their anger towards another person that causes their rush of hormones that results in a heart attack, you're not telling this court that that's homicide by heart attack, are you?
Yes, homicide with the medical definition is death at the hands of another.
That wasn't his question. He said if he gets angry.
I know, but you're here on behalf of the Commonwealth to support the idea that it's McGee conduct that you read in a police report
Perceived conduct that you read in a
that
police
is
report
responsible for the death.
is responsible for the death.
And you're saying that even if you would agree with me that even if then it was only the anger that Mr. Savitz felt toward Miss McGee, and his anger caused him to drop dead because of the same rush of hormones.
Yes.
Even if his own anger
All
caused
right,
his death.
I'm sorry, we've got to do another
This is
matter at
homicide?
11:15, so why don't we recess now? And we'll come back at 11:30, right? All right, Jim, do you want, Paul, can you bring in Mr. Owen, please?
I just don't know if all people are here.
Do we need to get?
Do you want me to get off?
All right, please.
They have another matter. They have to bring in another defendant. Let's take this down for a second. I don't know if they're going to cut the Zoom off, but we're not going to listen to it anyway. But hopefully they won't make us log back in. Okay, it's muted for now. What the duck did we just listen to? This is insane. While we're here, let's take a look at those, the name document that the medical examiner is referring to. And here it is. These are the, let me make them bigger for you. Guide for the Manner of Death Classification. This is by the National Association of Medical Examiners. And this is what the medical examiner is basing her manner of death on. She's calling this a homicide. First part of this that she refers to in her testimony, or that she was cross-examined with, is, I believe, paragraph 3. Which says the following. This book is a guide. The recommendations contained herein are not standards and should not be used to evaluate the performance of a given certifier in a given case. Death certification and manner of death classification require judgment, and room must be allowed for discretion on a case-by-case basis. The second part that she relied upon, or that she was cross-examined on, is paragraph 28. Which we will read and look at together. And this is death resulting from fear/fright induced by verbal assault, threats of physical harm, or through acts, there's an of missing there, through acts, aggression intended to instill fear or fright, may, keyword being may, be classified as homicide. Oops. Okay, that's weird. It's not where my cursor is, but whatever. if there is a close temporal relationship between the incident and the death. Examples include someone who has an acute cardiac death while being verbally assaulted, someone who dies in an auto crash while being chased by another to instill fear or panic, someone who dies suddenly immediately after being bitten, and someone who dies suddenly when someone scares them by popping up in a window and yelling boo with an apparent intent to scare or instill fear. What? I'm going to read that last part again. Someone who dies suddenly when someone scares them by popping up in a window and yelling boo with an apparent intent to scare or instill fear. Yeah, what the duck? In general, the time interval to establish the causal relationship between minor injury and collapse followed by death, or those involving acute cardiac deaths following fright, must be very short during the stress-inducing episode or immediate emotional response period, a few minutes or less. Yeah, they should just put an end to Halloween. They should just actually outlaw Halloween. Because if you yell boo to someone and you pop in a window and yell boo, and that person has a heart condition, including a 90% occlusion of the left and right descending arteries, coronary arteries, then and diabetes and a prior stroke and liver damage and all kinds of other things, you too can be charged with homicide, manslaughter, and the medical examiner may classify the death of this person as homicide. I don't know what world we're living in, but I think that this medical examiner, Rebecca Dedrick, has taken this to a whole other level of duckery. Yeah, boo is now attempted murder. And she's getting a little combative on the stand. His cross-examination so far, what I can hear of it, has been great. I'm trying to repeat his questions to you because I know that he likes to wander around the courtroom, Larry Tipton, and he does not like to stand in front of a mic. Yeah, I wonder if this is her first heart attack by perceived emotions death. And so in addition to these name standards, they're also talking about two peer-reviewed articles about homicide by argument, one in 1978 by Dr. Davis and one in 2004 by Dr. Turner. And he's trying to get her to admit that the Davis article says that there must be a criminal act with such severity with intent to kill or maim a person. And then she pointed out, yes, but in the 2004 article by Dr. Turner, they changed that, and it doesn't need to be a criminal act anymore, but it needs to be intent to frighten, injure, or kill. So a verbal and or physical act must be of such severity and I can't read my own chicken scratch, with intent to frighten, injure, or kill. I am going to submit to you that this is insane, number one. But number two, did Penny attempt to frighten, injure, or maim, or kill her ex-husband, Andrew Saviitz, by having a verbal altercation with him? Because at this point, based on these guidelines, it doesn't matter whether she touched him or not. Halloween has just been canceled in Norfolk County. We aren't even living in the upside down anymore. I would submit to you that a more experienced medical examiner would never have called this a homicide. I would submit to you, and I hope he asks her whether any detectives from the MSP tried to strong arm her into changing her manner of death from undetermined to homicide. She testified that it was 90 days before she determined it was a homicide. She testified that she relied on the police reports. But if she relied on the police reports, why didn't she read the statement from Penny McGee, who said that she was dragged around by the hair by her ex-husband, Andrew Saviitz, during this altercation and thrown up against the wall and the stove, because actually this medical examiner said, even if it was self-defense, it doesn't matter to me. I'd still rule it a homicide. But she said there was nothing in the police report to indicate it was self-defense. But I would submit to you that if Penny McGee's statement was in there, and she said she was being dragged around by her hair and slammed up against the stove and the wall, could self-defense be inferred? Penny McGee wasn't indicted until a year later in February of 2021, apparently. I don't get speechless often, but I'm a little bit speechless right now. So hopefully you have some questions and comments, and we'll talk about them until they come back at, what'd you say, 11:20? It's 11:18. Steve Kelsey, thanks for the 10. Since we can now murder via free speech, can someone get murdered if I pray too hard near them? Death by free speech? Death by freedom of religion? Your guess is as good as mine, Steve. Thanks for your super chat. Lori, thank you so much for tuning in from Canada and for your super sticker. Desert Quill, thanks for your 5. Decedent knows his own medical history. Why then is he not at fault for not walking away from an argument? Well, because this medical examiner wants to rule it a homicide. And we know that the detective Kakowski from the MSP, who was in the room when she did the autopsy, was in the group text message thread with Michael Proctor 2 years later, when he was talking about looking for nudes in Karen Reed's phone. Maybe during the conversation where they were calling it a rookie move that Proctor and Buchanan weren't able to get the medical examiner to change her cause of her manner of death from undetermined to homicide. Different medical examiner. I would submit to you that those questions would be fair game on cross. However, Dr. Russell is the GOAT. Thank you. Dr. Russell is the GOAT for tuning in from Norway. How did she decide afraid versus angry? Mind reading. Exactly. She's saying that she interpreted Andrew Savitz's perception of what he was feeling, and then she threw out but for causation. But for this argument, he would not have died right then and there. He could have died walking the dog based on the medical history that I heard about. Again, great question. She's explaining herself, but in my opinion, this is incredibly crazy testimony. And because this testimony is under oath, this medical examiner, Rebecca Dedrick, can be cross-examined about this testimony as well in other cases. So God save the Commonwealth, Tanya Nut Wahlberg. I am right there with you. Husky Lover, thank you for being here for 10 months. Love you, Melanie. You're the best. I think she was bullied into ruling it a homicide, and she's using this guideline book to try and justify it. I think you might be onto something there. Thanks for hanging out with me for 10 months and for your valuable insight. We are on break right now. The court is on break for a few more minutes. They're hearing another case. Brooke, look at page 6, the third bullet. All right. All righty. I'll allow it. I'm sure that he's got some more cross-examination for her since he's got a copy of this. Let us do that for Brooke and for all of you, because we're learning about the National Association of Medical Examiners Handbook, third bullet. Homicide occurs when death results from a volitional act committed by another person to cause fear, harm, or death. Intent to cause death is a common element, but is not required for classification as homicide. More below. It is to be emphasized that the classification of homicide for the purposes of death certification is a neutral term. Yes, that's what they were just talking about, right? A neutral term, and neither indicates nor implies criminal intent, which remains a determination within the province of legal processes. Great point. I still am flummoxed that there are peer-reviewed articles about death by argument. We learn something new every day here. Every day. And God says, in the end, what will Bev do? WWBD. Who's going to make the bracelets for that? The loopholes of it all. My crystal ball is broken today, Moon Goddess. How about yours? In page 22, second paragraph of the guide literally says to call this situation natural. All right, let's do it. Let's go to page 22. Anybody's got the bat phone to Larry Tipton. I'm sure he's on it, but let's find it. Page 22. Twenty-one, 22. Page 22, second paragraph. Look at you. Brooke, did you read this whole entire thing while we were sitting on stream? Or are you a medical examiner and you know it by heart? Paragraph 2 on page 22. Scared to death. It's called. One reviewer was concerned that a death during an exclusively verbal argument, such as acute cardiac death, might be classified as homicide based on the principles in this guide. Parens, that was not the intent of the principles. Solely verbal arguments tend to escalate because of mutual participation of the parties. That situation differs from one in which one party commits a volitional act, such as yelling boo at a frail elderly person with the apparent intent to scare or become alarmed, which constitutes assault. Okay? We know from the testimony of Zuzi, the daughter, that she heard an argument downstairs between two people, and she at first thought it was her father arguing with Harry. That indicates to me that either she only heard her father's, that she may have only heard her father's voice in the argument. Because had she heard her mother's voice, she would have known that he was arguing with her mother. That's another great argument that I just thought of. He was the aggressor. He was the one yelling at her because Zuzi said so. It goes on to say, in this latter type of case, classification as homicide may be appropriate. Acute cardiac death precipitated by the stress of, quote, normal activities and events of daily life, such as a vigorous verbal argument, is regarded as natural, akin mechanistically to sudden death after consensual conventional sexual activity. Well, there you go. Vigorous verbal argument is regarded as natural. Brooke, you are on it. Thank you for your super chat and for teaching us all a little something about the National Association of Medical Examiners guidelines when conducting autopsies. Wow, just wow. We're in the matrix. Exactly. Over and out. Although we know that, I don't know that the judge knows that, because I don't know that Larry Tipton, well, he definitely hasn't pointed that out yet to the judge. But we're here for it in case he decides to. Pin it on the girl, says Clerk Jim Clown. Pin it on the girl. I mean, what the duck are we doing here, my friends? What the duck? Send pin 22 to the defense attorney. I don't know Larry Tipton. I do know that he's going to be representing Brian Walsh. So there's that. Somebody else said, keep reading. Okay, we'll keep reading. Because they have not put the sound back up yet. I hope they remember to put the sound back on. Death during a struggle. One reviewer thought that death during a struggle with another person should be ruled homicide if there was physical contact. In some cases, this is certainly appropriate, especially if the struggle was precipitated by a physical assault or battery initiated by the other person. There are, however, cases in which cardiac deaths occur from exertion that is job-related, such as running after a suspected bank robber or putting out a fire, in which a natural manner of death is appropriate. If such a death occurs during a felony committed by the second party, not the deceased, that death may be regarded as a homicide or felony murder by law enforcement authorities and the courts, but the medical classification of manner need not be based on an interpretation of such laws. is interesting. This is all very interesting. We're waiting. We're still waiting for them to come back. Oh, my browser has lost connection to my screen share audio. Really? Okay, so let's remove this. We'll stop it. We'll try and share it again. I may have to restart my browser. Hopefully, it'll be fine. No jump scares at the assisted living. Nope. Nope. My goodness. Here we are. Yeah, don't jinx it, Yuri's math teacher. Don't jinx it. 3,137 people here, none of whom have revealed themselves as trolls. So that's a good day. It's a good day. I know she's got a calendar this afternoon too. Let me just look at, because I have the daily calendar up. So let's see. They're still on cross of the medical examiner. So, and I know that they have a defense expert witness standing by in the hallway or somewhere in the courthouse, maybe downstairs in the basement. She did say she had another case at 11:15 that she was calling in, and let's see if civil court. Hold on. She does have more cases at 2:00, so I would imagine that she's after she finishes this 11:15 case. I don't know if they're going to take lunch or if she's going to let them finish. She might say, how much time do you have left for cross for the medical examiner? And then I think tomorrow's supposed to be a full day of court. So let's just hope that Law and Crime decides to send a camera in, because I would have liked to see the medical examiner's face while she's testifying. But again, there is no jury. So as long as the judge can see her face, I guess that's all that matters. Rosemary says he'd still be alive if he had taken better care of himself. He was a ticking time bomb. Many, many viewers pointed that out this morning as well. Honey, 2800 says, I'm not a troll, just a lurker. I listen off to the side while I do things. Yay, ADHD, yay. Same, where do we ask for a camera, Marissa? I don't know. Law and Crime was there on Friday, but today they're doing other things. So I don't know. I don't know why they didn't think a lot of people were interested in this case. They didn't think that. And I think maybe it might be. Somebody pointed out that we had more viewers watching it here than on Law and Crime on Friday. So maybe that's why they decided, or they were told to stay out of Norfolk, says Katie. They're covering Blake Lively, but that's in federal court, and there's usually no there's usually no cameras in the courtroom, so yeah, I'm just rewinding the Law and Crime coverage right now, and it's just Jesse Weber doing a piece. There's no camera in the courtroom of the Baldoni Lively thing. They've got some expert witnesses on. And I don't think there's going to be a camera in there because it's federal court. So I don't know why they're doing that. Whatevs. Whatevs. What's on court TV right now? Well, let's not direct people away. This trial? I mean, Law and Crime it says they're going to cover the hearing, but I know in federal court they are not allowed to have cameras in the courtroom. So I don't know if they're just talking about the case. I don't know. I have no idea. No idea. No more horror movies for Norfolk County. Clerk Jim, please do not forget to turn the Zoom back on when your 11:15 hearing is done. No, Judge Janine did not reach out to me. I don't expect that she will. I don't expect that she will. Wildman's mom says, well, they don't like the darkness in that place to be lit up as bright as you shine. Mel. I don't know. I don't know. No sneezes. Court TV is airing it, but there's no cameras in the courtroom. So how are they airing it? Hold on. What are they airing? I see right now, Court TV, YouTube is live with or is going to be live with ASAP Rocky. And then California versus Jesse Alvarez. I refuse to watch the Court TV live stream because of their commercials. I refuse. But you're watching now on Court TV. Watching what? Watching what? Oh. Well, yeah, I see you're watching it, but they're behind. So they're watching right now, they're watching the testimony of the ER doctor in this case that we watched earlier this morning. So they're behind. Okay, so they're doing it on a delay and you have to sit through the commercials and we're way ahead. We're on the cross-examination of the medical examiner. So I'm not going to switch over to that coverage. But if you want to watch it on another device and suffer through the Court TV commercials while you do it and miss half the testimony, I don't know that they're going to come to live coverage, but that is the doctor who testified this morning currently right now as such on the stand. And right now they're not even showing him. They're showing the defendant. But that is what they do. So we'll just show the defendant for a second. Here you go. So here's Penny. And this is from earlier. Let me see where the sound is. I thought you meant they were doing the Baldoni thing.
We intubated him and we continued with CPR.
And what was the result of the CPR after he was intubated?
The CPR, we were unable to obtain ROSC.
This is from earlier. We heard this already.
Did you continue to work on Mr. Savitz?
Per the documentation here, it appears that we worked on him for approximately 40 minutes.
40 minutes?
That's correct.
Still no sound up on the Zoom feed, so.
And at the end of the 40 minutes, what was the ultimate result?
A time of death was called.
And what was the time of death?
Time of death was 14 minutes past midnight. 0014.
Now, once the time of death is called, what happens?
So right as we are making the time of death situation, we essentially go through a protocol where we make sure that we have covered all the gamut of what we think is necessary in order to intervene. And at that time, we also take a look at the heart with the
This is a replay. If you've been here with me.
Rhythm. At that point, that happened.
From this morning, we heard this earlier.
His heart wasn't beating.
However, it was not televised live. So they are televising on a delay for whatever reason. On Court TV, you have to sit through the commercials and then they cut it off. So we're going to just get a look at this doc because we liked his voice. We liked his demeanor. We liked the way he explained things. But when the live Zoom feed comes back on, I'm going back to the Zoom feed because we're already into cross on the medical examiner.
And a time of death was called.
And once the time of death is called, what happens to Mr. Savitz?
So once the time of death is called, we then have a criteria that we use to determine whether or not a medical examiner should be called into the case. Per the record, Mr. Savitz didn't meet that criteria and the medical examiner was called.
And what was the criteria that was met?
So there are a number of different criteria that are used. I'm just going to pull up to here. The one that we had used to decide to call was, just take a look here. I apologize, I do not see that documented, the actual reason for calling the medical examiner.
I've read it, Ms. Blair, it's in the records that I read this weekend. So it's in it.
She was working on the weekend. She was reading records on the weekends. What?
If you have something that you want to look at, that's fine.
Okay, thank you, Your Honor. I will move on. In addition to notifying the medical examiner, did you notify anybody else of the passing of Mr. Savitz?
I did not personally, but it is the protocol of our team to usually do so. Usually by calling a social worker who then helps to coordinate the care.
Thank you, Dr. Olufadeji. I have no further questions.
My pleasure.
Mr. Tipton?
Hi. Good morning.
So
This is Larry
would
Tipton.
the procedure be that when someone comes into the ER, and you begin to attend to a view of your team, that eventually clothes are removed?
Not in all cases.
Do you know if they were removed in this?
I do not recall.
And if you do, I know that you will, but do you recognize the name of Nick Giusti?
I do not.
But there is a procedure and policy of Beth Israel that if clothes or items are removed and someone deceased, is it your understanding that clothes then are transferred to the police, or the Mass State Police, whoever's attending to the death?
I do not know that.
What is pericardial effusion?
Pericardial effusion is when there is a fluid around the heart. That fluid can be from a number of different things. It could be blood, it could be serous fluid, but yes, that is what a pericardial effusion is.
And do you recall that in fact you saw no pericardial effusion?
Per my documentation, that is correct.
So there was no fluid around the heart?
Not at the time that we obtained the ultrasound.
And you did you administer something like a defibrillator at the ER?
That is correct.
How many times did you do that?
For the record here, we attempted defibrillation twice in the emergency department.
Twice.
Yes.
And if you know, from what you observed or what you might recall, do you know if a defibrillator had been used on Mr. Savitz before he arrived?
Yes, per the record that we received from EMS, there had been an attempt to defibrillate him before he got to the emergency department.
May I approach, Your Honor?
Yes.
Doctor, I'm going to show you a photograph, and I'm going to ask you, can you identify that photograph? Is that the patient that you administered?
I do not recall.
If you look at that photograph, do you see red markings anywhere?
I do see red markings on what appears to be the left side of the chest.
And are those consistent with the application of the defibrillator?
Not necessarily.
They could be, but
They could be, but unclear in this case.
all right. And also, is there an instrument in?
No, this
the
is a
mouth?
repeat of what we watched this morning because Court TV is only showing it on their website on a delay. We were on Zoom in the middle of cross-examination of the medical examiner. So while this is now finally on Court TV, we already listened to it, but now we're getting a look at the emergency room doctor. And I'm not mad about it.
Of the patient depicted in the,
Yes, there is an
What is
instrument.
that?
This is an endotracheal tube.
and in fact, was that applied to Mr. Savitz according to your records?
That is correct. He was intubated, as I mentioned earlier.
And
Hey, Baker
at
Raid.
this time, Your Honor, I move to introduce this.
No objection, Your Honor.
We don't need to publish that. We don't.
Welcome to the homicide by argument trial.
Your Honor, I think that this should be exhibit number 65.
That's what Diane just said.
Nope, oh, 65, okay, because we had put.
Notice Judge Beverly Cannone on the bench. Notice same courtroom that the Karen Reed trial was tried in. Notice this is Jennifer Blair, the assistant. Oh, they're coming back on the Zoom, guys. I'm sorry, I'm switching back. We are in the middle of cross-examination of the medical examiner.
All right, Mr. Tipton, go right ahead.
If you ever want to know who's testifying, it's at the bottom of the screen.
That your testimony here today, that if a person attacks another person, and the person who attacked the person drops dead of a heart attack in the moment of attacking that person, that other person who survived the attack is guilty of homicide by heart attack?
Yes.
Welcome to the upside down.
Even though the person who was, in your opinion, attacked, defended themselves, had no intent, criminal intent at all.
Objection.
They're still guilty of homicide by heart attack?
Even
Your
if
Honor,
they,
the question is asking the doctor to opine on a legal issue, and
She already
it's
opined
been
So you
it.
have to ask the
not her
question.
expertise.
You have to ask the question differently.
When I talk about guilty of homicide by heart attack, I apologize. What you're doing as a medical examiner is saying that there was a, quote, precipitating event that caused the rush of hormones that was the cause of the person succumbing to a heart attack, correct?
Yes.
So where someone defends themselves against an attacker, what is the precipitating event for purposes of finding homicide as the manner of death?
As I said previously, the medical examiner definition of homicide is death at the hands of another, which indicates that there are two people involved. Therefore, the victim, or the decedent, is one of two people who were involved in that precipitating event, regardless of the intent.
Everybody smash the like button.
Are you applying when you make that type of opinion? Are you applying all 5 factors found in Davis and Turner?
There are two separate issues. The definite,
Can you answer that question, yes or no?
in Davis, no, I'm using the updated guidelines to make that designation.
So you're using, okay, let's focus on Turner. Are you ignoring and not applying all 5 factors before you make a finding that manner of death is homicide at the hands of another?
Am I ignoring them? No.
So then, once again, what did you use then for factor number 1 in Turner in this case, determine that there was an intent to do harm on the part of Ms. McGee? So she's responsible for the cardiac event.
There is perception of intent on the part of the victim.
Where is that in this case?
I don't understand the question.
Well,
The fact is there are two people involved in a witnessed discussion or altercation, and one of them collapsed with an arrhythmia.
And had a heart attack.
But where's the intent to do harm on behalf of Ms. McGee? The first criteria found not only in Turner, but also in Davis.
It is the perception of intent to frighten.
How do you know what his
So
perception
the
was? He's
decedent
dead.
perceived that there was some intent of
Perception of the
fear
dead guy.
to be frightened, and that is what caused the dysrhythmia.
Okay, let me focus on that then. So are you making that assessment? You're saying that you have now determined that Mr. Savitz perceived fear,
Yes,
and you base that on the police report.
yes.
And when you were asked about the police report on a moment ago before we broke, you said something about, you don't remember reading anything about self-defense in the police report.
It has been a bit of time since I have read it. If there is something there, I don't mind you showing it to me.
Good. Would you change your opinion?
I'm asking you.
My recollection is that I do not remember that. If it is in there,
Please show it
It's
to
in
me.
there what?
if it is in there and there is something that you would like to show me, please do.
But
But
to me, like what you're telling me, okay, let me do it. Let me do it that way then.
may I finish my statement?
No?
Yes.
Pardon? Can you do what?
Finish your answer.
Oh, I'm sorry.
What I was going to say is, again, in order to use the medical definition of homicide, two people are involved, the decedent and another person. I hope that's not in question. So in this situation, there are two people who were witnessed to be involved, and then one of them ultimately had an arrhythmia.
Had a heart attack and died.
Is it not the connection then? Is it not the connection then that it's the actual conduct on the part of Miss McGee that caused the rush of hormones? Isn't that a requirement?
As I said before we broke, there's a concept in forensic pathology of but for, which indicates that if there were an ordinary situation where a decedent was going through their activities of daily living, so eating, doing laundry, whatever is typical of that decedent, they would not have experienced the event. So but for whatever this new event is, that is what explains the immediate proximate cause of death. So the discussion that night before the decedent had the arrhythmia was out of the ordinary.
Really? He had had a stroke 6 months prior.
What do you know about the relationship between Miss McGee and Mr. Savitz?
Right. What do you know about the
I
relationship?
acknowledge that I don't. This could be an everyday event for them. That is true.
Well, if it's an everyday event, then it doesn't comport with your decisional process to reach the conclusion you have in this case.
Acknowledged, but the temporality of an argument and then an arrhythmia cannot be ignored.
I'm not asking you to ignore it. But it's only one of the 5 factors. You would agree with that, wouldn't you?
Which fact?
The temporal connection is only one of the 5 factors.
Yes. Would you like me to address the others?
I'm just asking you, that's only one of the factors.
That is one of them.
And you don't know anything before you made your finding. And once again, let's be clear. I want the record to be very clear here. You're saying that it was Miss McGee's conduct was the precipitating event.
Yes.
And her conduct caused the rush of hormones, correct?
Yes.
And it was the rush of hormones that resulted, your opinion, in the cardiac event, correct?
In my medical opinion, yes.
And is that medical opinion? What degree of certainty is that?
Well beyond 50%.
That what? Her conduct, Miss McGee's conduct was the precipitating event?
The events of that evening were the precipitating factors resulting in the arrhythmia. Yes.
But what you're saying is it was Miss McGee's conduct.
It was the
Right.
conduct of the two individuals who were involved.
Then how are you
the
charging her with
decedent
homicide?
and Miss McGee.
With manslaughter?
Yes.
So, nowhere, you'd agree with me, won't you, that nowhere in the Turner 5 factors or in the Davis 5 factors does it say anything like what you just said?
No, I do not agree with that.
You would agree with me that the precipitating event is what event caused the rush of hormones. Would you agree with me on that?
Yes.
And a rush of hormones can be caused by anger in the person himself, correct?
Yes.
And the rush of hormones from the anger in the person who ultimately has a cardiac event, that anger is what caused the rush of hormones, correct?
Yes.
So in a case like that, where it is the anger of the person who had a cardiac event, his own anger is the precipitating event.
Is there a question?
Yes,
I'm sorry, could you repeat the question?
it's his own anger that caused his hormones to rush is the precipitating event.
If it could be proven that he was angry independently by himself, then this would not be a homicide. However, there was another person involved.
Oh, because the other person was in the
medical
room.
definition
Got it.
is death at the hands of another, homicide.
You are so wrong, and your credibility
Hands is
in the
metaphorical.
future.
I understand, it's not literal, but at the hands of another. You're saying that, once again, Miss McGee is responsible for the rush of hormones when it could have been
Himself, his own
Mr.
reaction.
Savitz's own anger that caused the rush of hormones.
Yes. And to clarify, the anger had to be precipitated. If he was all by himself, we'd be having a very different discussion.
Oh, so just because there's another person in the room, you can charge,
Can you
call it a
clarify that?
homicide?
You said it had to be precipitated by who? Who caused the anger?
That's my point. So if you could prove that Mr. Savitz was all alone
He
and
doesn't have to prove
became
anything.
angry and then died, we would be having a very different discussion. But he was angry in the presence of another person. Therefore, this becomes death at the hands of another. A second person is involved in the situation. And it is a medical definition, not a legal definition.
I understand that. But the government is relying on you to make the connection of who was responsible for the precipitating event that resulted in the cardiac event. Would you agree with that?
Yes.
And so if Mr. Savitz became belligerent and became angry and had a flood of hormones just because Ms. McGee's in the same room,
But there was a witness.
he's responsible?
Just because she's in the
There's
same
a
room. she's-
witness who said that they were interacting with each other. This is not a situation where she was sitting in the room, not interacting with him. Therefore, there were two people involved in the discussion per the reports that are part of my decision, which indicates that there were two people involved, not just the decedent.
Is it your testimony also in your medical opinion that someone can have a, quote, vigorous verbal argument and that would sustain a finding of manner of death such as you've made in this case?
Yes.
Doesn't the literature that you quoted so much talk about homicide by heart attack doesn't include just vigorous verbal argument?
No, some of these documents do say that it can be pure.
Right. Angry in the presence of another person makes it a homicide, Kelly. Yes. Apparently, according to this medical examiner.
As we've discussed in the name guidelines on page 13, that paragraph 28, deaths resulting from fear/fright induced by verbal assault.
Okay, now go to page 22, Larry.
And you mean that's just a verbal argument?
Yes.
Larry, page 22. If you say boo to somebody.
Ask you this before I forget again.
Death in the presence
So I'm going to
of
give you a
another.
hypothetical.
Okay.
The two people, Ms. McGee and Mr. Savitz, were having a discussion that escalated into a verbal argument. And Mr. Savitz became belligerent. And assuming for the next fact that he told her to get out of the house, and he pushed her against the living room wall.
That was Penny's
And
statement.
assuming the next fact in the hypothetical, he continued pushing her several times, pushing her into the adjacent kitchen dining room area. And for the next fact, for this hypothetical, he pushed her into the kitchen table, which resulted in several plates being knocked off the table and broke on the kitchen floor. Next fact, he then pushed her into the kitchen refrigerator, grabbed her by the hair, and began to push her down the hallway towards the front door. And the final fact is, when they entered the front hallway, Mr. Savitz fell and collapsed. Based on that hypothetical, is it your opinion then that the precipitating event that resulted in the cardiac event at issue was not Mr. Savitz's own anger and his own conduct in assaulting Ms. McGee and pushing her into a wall and then pushing her into the kitchen and then pushing her into kitchen appliances and then pushing her down the hallway? And while he's pushing her and grabbing her hair, he collapses. Are you saying that it's still somehow she's responsible, she's the precipitating event?
Yes, per the medical definition
Wow.
of homicide.
Wow. She made him angry, so it's her fault, says Kelly. Yeah.
And what I just gave you is a hypothetical. I'm going to show you. May I approach Your Honor?
Yes. Tell Ms. Blair what you have.
Medical examiner's name is scrolling along the bottom. It's Dr. Rebecca Dedrick.
Starting at the bottom paragraph?
Yep.
That's the Brookline police report that you had in your file, correct?
And I apologize. Yes, I have read this. It has just been a bit of time since I've seen it.
Do you need a
And
minute to look at
Didn't
it? Jen?
factor
okay.
into your homicide
Hearing it refreshed my
determination.
memory.
It's cause of death or manner of death.
And it's fair to say that as a medical examiner, when you're relying on police reports such as this that are reciting facts, but as a medical examiner, you don't pick and choose which facts you believe or disbelieve, do you?
No, of course not.
So you must consider all of the facts in the police report, correct?
Yes.
But it's still your testimony then today, in your opinion, that someone merely exercising self-defense, that their exercise of self-defense is the so-called precipitating event that led to the cardiac event.
Yes.
Can you show us, Dr. Dedrick, and I have to get my copy back because I've lost all my...
So I do need to make this an identification, marked for identification. All right, so is that the only copy we have of this? We can mark it for ID and you can take it back. Okay.
Remember, initially,
Thank
this
you.
medical examiner said she went over the police report. She doesn't remember seeing anything about self-defense. Now she's admitting that she read Penny's statement and she still ruled it a homicide. Welcome to Norfolk County. Welcome to the courtroom of Judge Beverly Cannone, where anything is possible. The upside down is right side up. Am I right side up or upside down? We've entered the matrix, the twilight zone.
When you talk about, self-defense and exercising self-defense, would you agree that if someone was exercising self-defense, that they don't have an intent to harm or frighten someone? Would you agree with that?
With the way that we are defining this, with the way that I came up with my cause and manner of death, it is taking into account that there can be perception of intent to frighten or harm or cause fear.
Doctor, are you a psychic?
And that is how I make my designation.
But you already told us you're making an assumption without any underlying facts when you talk about perception of fear on behalf of Mr. Savitz.
Yes, to a reasonable degree of medical certainty.
Okay, be whatever certainty, but you don't have any facts to support that. Is that fair to say?
No. There were other.
No, I have no facts to support
in
that.
In the police reports, there was documentation that the decedent's daughter had been witness to what had been happening as well.
It's a real reach.
Anything in that police report you're referring to that's the same one that's now been marked for ID? Was there anything in that police report where the daughter says her father was in fear?
No.
Was there anything in that police report that said that you felt frightened?
No.
Did you listen to the 911 tape?
No, I have not heard the 911 tape, but I saw the documentation of it.
You saw the document?
That was contained in the police report.
So you didn't listen to the 911 tape where you can hear the same daughter that's quoted in that police report repeatedly saying, "Dad, stop, Dad, stop." You didn't hear that?
No, I saw it written out, however.
And
did you consult a Ouija board, doctor, to get the decedent's perception of fear?
you talked about NAME, National Association of Medical Examiners.
Yes.
Does that have an official publication?
I'm not sure offhand.
Academic forensic pathology?
I'm sorry, can you?
Academic forensic pathology? Isn't that the official publication of the National Association of Medical Examiners?
I'm honestly not sure at this moment.
You rely on publications emanating from the National Association of Medical Examiners, don't you?
Sometimes, yes.
Okay, well, the diet is from the National Association of Medical Examiners, correct?
Yes.
Thank you,
when you talk about
but they're
literature,
behind. We've already listened to
Dr.
that
Dees,
testimony. Thank you, though.
Are you familiar with a piece of literature dated 2018 entitled Manner of Death Certification After Significant Emotional Stress? Are you familiar with that?
May I see it? Yes, I have seen it. Just give me a second. Yes, I have seen this.
And you're familiar with this. I know you don't have it committed to memory, but you are familiar with it, aren't you?
I am, yes.
And this document, published in 2018, was about these cases where someone has a cardiac event as a result of an exciting event or a precipitating event.
Yes, that is correct.
And it's fair to say that it was trying to measure the variability between different medical examiners across the country in making their findings, correct?
Yes.
And it demonstrated that in many cases, there was wide variability, correct?
Yes.
There was no consensus on finding homicide as opposed to accidental, as opposed to undetermined, correct?
Yes.
And at the end of this multi-page piece of literature published in 2018, it talks about the need to revisit those guidelines and address what they refer to in this article as the controversial findings of manner of death in cases like this, correct?
Yes. However, the cases that are in that article are not exactly like this case.
No, they cover a wide variety of cases, correct?
And nothing is completely concordant with this type of case.
But there has been no modification as recommended in 2018 to those 2002 guidelines.
That is correct.
And when you say they're not the same, you do know that one of the 8 scenarios was number 4, and it involved someone being robbed.
I don't remember offhand what scenario number 4 was.
Well, let's read it into the record, shall we?
Yes. And maybe we can have this marked for ID.
Okay.
She's
Who's
really
the
doubling
author?
down.
It's a variety of authors, Judge.
Okay. That's okay, I'll just do,
There's Nakova, Leon, and Gilliard.
thank you.
Yes, you're
All
right,
documents.
AJ.
Oh, well, this one.
Thank you.
AJK says we
And I want to
know.
focus your attention then on page 697, case number 4, death after an alleged robbery, correct?
Yes.
And without going into great detail, and you can correct me if I say anything wrong, a 57-year-old man with a history of heart issues collapsed at the scene of an alleged armed robbery, correct?
Yes.
And so the question was, what would be the manner of death in a case like that, correct?
Yes.
If you recall, Dr. Dedrick, you recall that based on the survey of all the various medical examiners, hundreds of medical examiners, there was a great discrepancy, wasn't there?
There was.
And one of the reasons there was a great discrepancy is because in the scenario, the medical examiners could not conclude that a robbery occurred as opposed that it didn't occur.
Yes. There was no one there with the decedent at the time of collapse.
But there was no question that the person collapsed as a result of a precipitating event that was supposed to be a robbery, correct?
Right.
There was another person involved.
Allegedly, but there was no witness, so it's not comparable.
Stop. You can't be serious right now. Only if
In
there's
this
a witness is it a homicide, in your opinion. Really?
That the authors say that the establishment of causation between a stressful event, such as confrontation, a motor vehicle accident, or a robbery is the first and most important step in certification of manner of death. That's at page 694, first page.
Give me 1 second.
Second page.
This is insane.
Where are you?
On page 6.
694.
We all want to know where we
Oh,
are.
okay. On the second
Where
paragraph.
are we?
Yes.
We're in the
authors
matrix,
also
babe.
say with regard to these cases that the association between precipitating events and death can be uncertain and complicated by underlying medical conditions and/or unusual circumstances, correct?
Yes.
I mean, it says that certification as accident, suicide, or homicide requires a higher degree of certainty, correct?
Yes.
And page 694, it says a stricter burden of proof is required to decrease the risk of false conviction and to reduce the social cost of sanctions, correct?
Yes.
This paper, as we go through quotes in this paper, it's demonstrating, doesn't it, how difficult and complex these cases are.
They can be. Yes.
And in nowhere in any of the scenarios in this case do they ever have a scenario where there is, in fact, self-defense, do they?
No, they do not.
And in fact, in the 4 scenarios that were relied upon by Dr. Turner, there's no scenario involving self-defense, is there?
No, I do not believe there was.
And in fact, you can't cite one piece of literature, can you, relative to this type of manner of death finding where anybody has discussed the issue of self-defense and applied it to the rubric of reaching a manner of death, as was done in this case, can you?
No.
Because nobody ever talks about self-defense in the literature with regards to this type of manner of death, correct?
Correct.
And that is because when someone is exercising self-defense, they have no criminal intent. They're defending themselves, correct?
That is correct.
So, reason it's unnecessary to talk in the literature, to write about cases involving self-defense and manner of death is because there's never a finding of homicide in the literature and in the case, relative cases, where someone has exercised self-defense, correct? That you're aware of.
That I am aware of.
I'm speechless.
In fact, it was the confusion about finding these manner of death decisions that prompted, according to this article I'm quoting from page 695, this guide to manner of death certification, correct?
Yes.
That's what we're talking about. And that paper specifically talks and discusses about the 5 factors found in Davis and Turner, doesn't it?
Yes, it does.
It sets out a table in the paper and discusses the 5 factors and the need to apply those 5 factors, doesn't it?
It does.
And the 5 factors, once again, whether you talk about the Davis
It
number
wasn't a
1
homicide,
factor,
actually.
or the Turner number 1 factor, you were talking about
I get your
someone
point.
with the intent to do harm, maim, to kill, to commit a criminal act, correct?
When it's revised, it no longer says criminal act
But it says intent to kill, right?
or frighten.
Right. So you would agree with all that, right?
Yes.
And so in this case, you are assuming that Mr. Savitz was experiencing fear or fright, correct?
I am assuming that, yes.
But you're assuming it without any evidence that in fact he did experience fear or fright.
In this article as well, it discusses that concept of but for, meaning without the event, the person would not have passed away.
But
How can you
without
make
the
that
event
determination?
That includes a person's intent, the perpetrator, so to speak, intent to cause harm or cause fear.
Or perceived fear.
No, it doesn't. Show me in that article where it says perceived fear.
Yeah, show 'em.
There are quite a few pages in this article. It
Well,
would take me
we'll wait.
a bit of time to go through it.
We'll wait. We've got time.
I shouldn't ask you that question.
Tell her
You
it's
would
not
agree
in
that
there.
on page 703, the authors say the determination of the manner of death in such cases is complicated and controversial.
Yes, I do agree with that statement.
We also agree with the authors who note that a stressful event may or may not hasten the death of one already vulnerable, correct?
I'm sorry, where is that?
Page 703.
Where about? Oh, I'm sorry, in the second full paragraph?
Mhm.
Yes.
And the page 703, same page. The certification of an unusual manner of death requires the establishment of a causal relationship between the precipitating event and the death. You agree with that?
Yes.
The same paragraph, the next sentence. However, there are some situations where causal relationships are unclear and controversial, correct?
Yes.
One of those instances is death after a robbery, correct?
An alleged robbery that was unwitnessed.
Well, we all understand that you'd have to have at least 2 people involved. One's dead and one survived, correct?
In the situation for the decedent that I did the autopsy on, yes. The scenario in this article to which you're referring, the way that the scenario is laid out is that there were no witnesses. It was an alleged robbery. There was not a known second person.
So he robbed
The two
himself?
situations aren't comparable.
You've lost all credibility.
The authors go on to 704 and say the investigational evidence can be unclear, incorrect, or both. Correct?
In the third paragraph?
Yes.
Yes.
Inadequate investigation finding to limit the certifier ability to determine the correct manner of death. Correct?
Yes.
And the National Association of Medical Examiners, is quoted in this and is stated in this article, says that making a manner of death opinion in cases like this is circumstance dependent, not autopsy dependent, correct?
Yes.
So you have to consider all of the circumstances involved before you can reach a manner of death as you did in this case, correct?
Yes.
And once again, circumstances that you were presented with included circumstances where Miss McGee was attacked, struck, pushed, grabbed by the hair, and while that was going on, Mr. Savitz collapsed, correct?
Yes.
But it's your opinion that since she was there, it's not Mr. Savitz's own conduct or anger that caused the rush of hormones. Somehow it's her conduct.
Yes. The fact that there were two people there during the discussion, during the altercation, whether it was verbal or physical or both, yes, the fact that there were two people present in the time immediately leading to his death, it is still death at the hands of another, the medical definition.
Yeah, but once again, I'm just, death at the hands of another, you're simply saying,
Dr. Rebecca
you use
Dedrick.
that phrase, that it's her fault.
Did she do Sandra Birchmore's
Miss McGee's fault
autopsy?
for the cardiac event.
Yes.
When in fact the cardiac event would have been the result of Mr. Savitz's own anger, correct?
Yes. But
It could have been the result of his own anger, correct?
Yes, but there was another
Yes.
person in the room.
And it could have been the result of his own physical assertion in striking her, pushing her down the hall, and grabbing her hair, correct?
yes.
Making your manner of death opinion in this case, you also relied on the injuries that you observed, correct?
No, they were not the primary factor in the determination. Had he not had anything on the external, if he had not had any injuries externally, it would not have changed my cause of death.
Okay.
The pieces that make my determination for cause of death are the arrhythmia that was known, the fact that he was witnessed to be with Ms. McGee and had a discussion, and his underlying medical history. At no point did I include blunt force injuries in my cause of death. My cause of death does not say blunt force injuries.
Okay. Doesn't matter if she touched him or not. Just the fact that Ms. McGee was in the room.
It is on the final diagnosis page of my
This
autopsy
medical
report,
examiner.
but that is not part of my cause of death.
It's a homicide.
Did you ask that very question, the grand jury presentment, a year after this event happened on February 4th, 2021?
With all due respect, I have not changed my cause of death for this case.
I didn't ask you that. find it.
Thanks. He's finding it.
You recall you were asked something about fight or flight response, correct?
Yes.
Do you remember using that phrase before the grand jury?
I would need my memory refreshed. It was about 5 years ago.
Okay.
Yeah, this was January 28th and 29th of 2020. Same date as John O'Keefe, except John O'Keefe is 2022,
Memory is exhausted.
which is wild. Wild. Is your memory exhausted? My memory, my
64
brain
lines,
is exhausted from listening to this nonsense.
6 through 9. I'm going to show you a document and ask you to look at. You have that application. 64 pages. Actually, read line 6 through 9.
I'm sorry, 6 through 9, you said?
Please, tell me when you're done.
Yes. Similar to what I said on direct earlier as well.
Let me ask you the question. He said that he was experiencing what we call kind of a fight or flight response.
Yes.
He was fighting.
And during that time, his body had a flood of hormones.
I feel it.
Yes.
You didn't say anything about, to the grand jury, about him striking and pushing Miss McGee, did you?
No, I did not.
And you didn't say anything about him grabbing her hair and pushing her down the hallway, did you?
No, I did not.
But when you testified in February of 2021, even though it was a year later, you still had the entire ME file at your disposal, right?
I did.
And it contained that same police report that's been marked for identification, didn't it?
Yes.
And before you testify before the grand jury, and you know you're going to testify under oath, it's important to have all the facts under your belt before you testify, correct?
Yes, of course.
So when you testified at the grand jury, you never told them anything about him, Mr. Savitz, striking and pushing and Miss McGee up against a wall or anything like that, did you?
I did not.
You basically based your opinion solely on the fact that in your assessment, Mr. Savitz, in your opinion, was experiencing fight or flight.
Yes, in my medical opinion.
Without consideration of the fact that the evidence you were relying on, the report you were relying on, indicated that he was assaulting Miss McGee.
That doesn't negate the fact that he's still experiencing fight or flight.
That doesn't.
Even if he's the aggressor.
You did not tell the grand jury anything
It doesn't
about
matter if he's the
what you
aggressor.
knew and the data you had reviewed that he was assaulting Miss McGee.
It is not under my purview to be describing that information. That's coming from the police reports. I review that information, but I wasn't there as a witness. I am testifying with my medical knowledge, which involves the autopsy.
But you're
and
weighing the witnesses'
a secondary review of
statements
those
in your
documents.
determination, ma'am.
Wait a minute. You relied on the content of the police report to make your
That's what
assessment that he was experiencing fight and flight response. Flight response.
Yes, and I stand by that.
Okay, but so you are giving the grand jury under oath opinions knowing there are other facts that contravene them.
No, I am not.
Tell the grand jury anything about him assaulting Ms. McGee?
No, I did not.
Wow, just wow.
Right, let me,
Should be Crunchy Frog a directed verdict, but will it be? Only Judge Cannone knows. You know, a jury might have believed it, everything she said. She's going by these national standards of the national medical
Grand jury,
examiners. It's bizarre.
Mr. McGee, grand jury, page 66, line 17 through 20.
Oh, he's got a grand jury testimony now.
You told the grand jury, didn't you, Dr. Dedrick, that is your notation of those physical aspects also something that you used in order to opine your cause of death? And you answered yes, correct?
May I see it?
Sure.
Oh, it's the Jennifer McCabe testimony trick. May I see it? What you're referring to, my grand jury testimony? May I see it? Give me the transcript.
Yes.
We're all in on the same joke here, right?
That
Says Brenda.
you relied on the physical aspects, that being the blunt trauma that you lived, in reaching your opinion.
I included that information in my thought process. I included them on the front page of my autopsy report. However, they did not come into account for the cause of death.
We can just then, I guess based on your prior testimony, we can agree that those 4 blunt trauma injuries, as you characterized them in the autopsy report, then they don't have anything to do with your cause of death.
That's correct.
And one of the reasons is, I think we heard you say it, you can't tell when those injuries occurred, correct?
Correct. They could be consistent with that day, or they could have been earlier.
And you just don't know.
I do not know.
And for instance, you described in your autopsy report the redness or something on his back, correct?
An abrasion.
And you are aware of the fact that he was administered CPR multiple times and it resulted in multiple broken ribs, correct?
Yes.
And it's fair to say that that abrasion you saw on his back could have been the direct result of all those efforts to resuscitate him that resulted in him breaking his ribs, correct?
Yes, which is why I did not include it in the cause of death.
So there is nothing then with regards to the injuries that your testimony here today is that nothing about the injuries inform your manner of death.
I took the information into account and then did not include it in my final cause of death, and it had no bearing on the manner of death.
And
Where are my Dedham people? You need to go to court. You need to free Penny McGee. This is insane.
when you were asked on direct examination about the minor lacerations in his mouth, that doesn't have anything to do with your manner of death.
I said, when asked if it could be possibly from intubation, it's uncommon, but yes.
So it doesn't have anything to do with your manner of death.
It did not impact the way that I phrased cause of death or my decision with manner of death. That's correct.
Once again, that injury, just like you just said, you don't even know how it happened. For that matter, you don't know when it happened.
That is correct. I said that.
But you did testify to the grand jury specifically about this ecchymosis around your left eye, correct?
I would have mentioned the periorbital ecchymosis.
And you told the grand jury that that was indicative then of a physical assault, or just that effect, right?
I said it could be consistent with a physical effect, or physical altercation.
Oh, she told the grand jury he had a black eye because it could have been a physical.
That the ecchymosis that you observed in Mr. Savitz's eye was the result of anything that Ms. McGee did, correct?
It could be consistent or it could be inconsistent. That is true.
You just don't know.
Grand jury
I
was
don't know.
hoodwinked.
And when you talk,
Well, Yuri
Did you
Buchanan
ever,
was involved, Trish. And Kotkowski.
did you ever try to find out the prior medical history of Mr. Savitz, prior being before January 28th or 29th of 2020?
I did not have those records.
And you could have gotten the records, though. You'd agree with me, right?
Potentially, yes.
Well, you have these request forms, correct, at the OCME's office?
Yes.
And in fact, you issued a number of those request forms for the Brookline Police Report, right?
Those don't come directly from me, but yes, those materials were requested.
And
Semantics.
you used that request form to get the Beth Israel medical records that you relied on.
Again, not me personally, but
I understand.
people in the office, yes.
But you have this mechanism for getting records if you want.
Yes.
And you would agree with me, wouldn't you, Doctor, that the observations you made, that you concluded that Mr. Savitz had a cardiac disease, that was only after you cut him open and observed him, right?
Yes, that's why a full autopsy is performed.
Well, I understand.
Donna, this is a bench trial, no jury, in front of Judge Cannone.
Layperson would not have known he had serious cardiac disease, correct?
Yes.
Yes.
Yes, a layperson may not know that.
Okay. I mean, and so you're unaware of the fact that he had a full heart workup just months before this incident, and his doctors all following him didn't find anything significantly wrong with his heart.
I was not aware, but what I saw at autopsy trumps any of that.
No, I understand that. We agree with that.
Okay.
What we're saying is that only after you performed your autopsy, that is, and I don't mean to be callous here, but when you opened him up and did the internal examination, that's only when you, as a pathologist, found out that he had serious cardiac disease, correct?
That is true.
And you're unaware, just as you sit here today, whether Mr. Savitz was otherwise a functioning human being, working, traveling, taking care of his children, right up until the day of this event, correct?
That is correct.
So you're unaware of any facts or evidence that a layperson would have knowledge, sufficient knowledge to understand that getting into an argument with him could result in a cardiac event and a heart attack. Correct?
I'm not entirely sure what you're asking. Can you say it in a different way?
That you know in this case, from you looking at the medical record and you conducting an autopsy on Mr. Savitz, there's nothing there to indicate to you that a layperson would know that getting into a verbal argument with Mr. Savitz could result in a heart attack.
That's correct.
Okay. And are you aware of the fact that Mr. Savitz had been in a car accident in August of 2019 where the car was totaled that he was driving?
No, I did not know that.
And in fact, cardiac events such as this, the literature has examples of people having a cardiac event as a direct result of a serious motor vehicle accident, correct?
That is true.
And are you aware, Dr. Dedrick, that in fact, 8 days before this event, 8 days on January 20th of 2020, that Mr. Savitz was involved in yet a second motor vehicle accident where that car was also totaled.
Oh.
Did you know that?
No,
Oh,
that was not brought to my attention.
So,
but you didn't do your homework, ma'am.
what you have is, you can't testify, can you, that someone would have knowledge that getting into an argument would result in Mr. Savitz having a heart attack, can you?
No.
I don't think Yuri's going to be testifying. I don't think so, because I think this is the prosecution's last witness. And then I know that the defense has an expert witness waiting, unless they're going to take out a turn.
That you first conducted your autopsy on January 30th, 2020, and the time that you signed your death certificate, I believe it's April 29th.
I believe that's correct.
Um,
April 24th of 2020.
Did you request any additional medical records?
I did not.
Did you request any more information from either the state police or the Brookline police about what exactly happened in that house before you met over?
No, I was told that the police reports that I had were complete.
Oh,
And did you, between the time you certified the death and the 8 or 9 months between April of 2020 and February of 2021, when you testified under oath to grand jury, is it fair to say you didn't seek any additional information or anything of the sort?
No, I did not.
It is fair to say that during the autopsy, you caused to have collected fingernail scrapings of Mr. Savitz, correct?
Yes,
And
clippings.
and those fingernail clippings were submitted to the Massachusetts State Police Crime Lab.
Yes.
Did you ever, before you made your finding of manner of death, did you ever inquire as to any testing results on those fingernail clippings?
No, but that is not a standard thing that we as medical examiners do.
but you're calling yourself a medical detective.
That's
You're
something that it's responsible the government does, like the Commonwealth?
I believe the Commonwealth does it, but it is not, as I said, it is not part of my purview. Therefore, I cannot answer that. I don't know who else.
so if
uses
under
them.
his fingernail clippings there were
That you, as the medical
her skin
examiner,
cells, like he was
you did
grabbing
not,
her,
collect or cause those fingernail
you wouldn't
scrapings
consider that.
to be what?
I collect them. They go into the chain of custody. They are
This
taken
chain
as
of custody?
evidence. And then I do not know the DNA results unless I am told them by the DA's office.
Oh, so that doesn't factor into your determination, only the police reports.
Did you ever, as a medical examiner, look at the clothing of Mr. Savitz to see if there was any evidence of blood or anything of the sort?
Clothing
No, that was not given to me as evidence.
wasn't given to her. She didn't ask for it. No
You could have
clothing?
asked for it, but
Yes, but it wasn't relevant to determining that cause of death.
Okay.
so
She says there's a chain of custody. We don't know. Well, we know Yuri Buchanan did an interview with the daughter Zuzzy. Did Detective Kutkowski, who was in the room with you when you did the autopsy, did you ask him any questions?
I apologize
Did he
to you and the court, but I did ask you a question
offer any information?
about 10 minutes ago about vigorous verbal argument. You recall that question?
Yes.
You would agree with the statement, when you acute cardiac death precipitated by the stress of normal activities and events of daily life, such as vigorous verbal argument, is regarded as natural.
Where are you reading that?
Reading that on your guide,
Can I see it?
page 22.
22. He's going to page 22, just like we told him to.
paragraph, Underlined with the caption, "Scared to death."
That's what we pointed out before. That's what you guys pointed out before. Scared to death.
Give me a moment to read that, please.
We got this, you guys. We got this. Telepathy to Larry Tipton, Esquire.
Yes,
Telepathy.
okay. I'm sorry, what is the question?
22. Scared to death.
The authors of your guide that you've relied on state acute cardiac death precipitated by the stress of normal activities and events of daily life, such as vigorous verbal argument, is regarded as natural.
Yes, we read that earlier.
Right?
Oh, yes.
It says that, yes.
Yes. Oh, yes. Oh, yes.
You agree with it, don't you?
Yes. Oh, yes. Oh, yes. We both reached
I
for
think you have to determine what is considered a vigorous verbal argument outside of normal daily living.
Okay. And when you said that earlier that vigorous verbal argument would in fact be a precipitating event. The people who you rely on, those people who wrote this guide that you've used your testimony here today, say the very opposite, don't they?
I'm sorry, can you repeat that?
They say homicide is not the manner of death when death results from vigorous verbal argument.
That's right.
When vigorous verbal argument is considered a normal activity of daily living.
You already told us that you don't know if
He's
vigorous verbal
divorced. Of
argument
course it's a normal
was
activity of
a
daily
normal
living.
activity between Mr. Savitz and Ms. McGee. You already told us.
That's true.
They're co-parenting for 6 years. They have a daughter who won't let the mother in the house, who's estranged. Of course, it's part of their daily activity. You would think it was case closed, 13 flags in a normal world. But we're not in a normal world.
I think I have to decide.
Sidebar. Sidebar. He got a telepathic message on page 22. I'm so excited. Are you so excited, my friends? Oh, yes. Oh, yes. Oh, yes. Oh, yes. Oh, yes. He got our message to go to page 22. I can't remember who pointed that out earlier, but it's all you. It's all you. I'll find it on the replay. It is all you, my friend, who went and read this pamphlet, this 29-page pamphlet of the National Association of Medical Examiners Guide. I don't think they're throwing this case out. So if you're just joining, welcome. This is a bench trial in front of the one, the only Justice Beverly J. Cannone. I don't know if it's J. Beverly Cannone in Norfolk County, Massachusetts, the same judge who tried the first persecution of Karen Reed, who will be on the retrial of Karen Reed. And for those of you who don't know what this case is about, Penelope McGee, is an alleged Rhode Island socialite who married a guy named Andrew Saviitz. Andrew Saviitz ran the 1988 presidential campaign of Michael Dukakis. He was well connected in the Democratic Party. They divorced. They'd been divorced for about 6 years. They have 3 children together. Penny had just been evicted from the home she lived in with her 3 children some of the time because the daughter, Zuzi, who was 18 and a senior in high school, did not get along with her mother at all, and she lived with the father. In fact, she gets evicted from the home that her brother-in-laws owned in a trust. They evicted her, and she's allowed to now stay at the house where the ex-husband lives and Zuzi lives, only if Zuzi is not there. We don't know what the beef was between mom and Zuzi, but Zuzi told the police that she doesn't even remember the last time she had a conversation with her mother. This is January 29th of 2020. Penny McGee had a verbal argument with her ex-husband because she went over there to yell at him because she got an eviction email from the brothers-in-law as such. And so they had a verbal argument and he dropped dead of a heart attack. Now, it should be pointed out that 6 months prior to that, he had a stroke. He also had hypertension. He was also, he had 90% occlusion or blockage in both the left and right descending, I think, coronary arteries and diabetes, and had been in 2 major car accidents within like 6 months of this event. One was in August of 2019. The other one was a couple weeks before as such, what this medical examiner wants you to think is a homicide. Penny McGee is now on trial. It's manslaughter by argument. She's on trial facing 20 years in prison. Her attorney, Larry Tipton, who is assigned counsel, he is a public defender. He's also representing Brian Walsh, is on fire. However, they've elected for a bench trial in front of Judge Cannone, so there is no jury. Perhaps Penny McGee watched the Karen Reed trial and said, "What the duck? I am not trusting my life in the hands of a Norfolk County jury." Very possible. This happened in Brookline. A lot of people did not know Brookline is Norfolk County, but it just is. Hi, Mama She. Thanks for the 20. Being here from the start, listening while working, and finally can say, hiya. And come on, Bev, you know the Commonwealth. Wrong. Thank you, Mama She, for tuning in and via Super Chat. And it was Brooke. It was Brooke who brought it to our attention That page 22, second paragraph of the guide, literally says to call this situation natural. And telepathically, or perhaps Larry Tipton was very prepared and he already had this. And I thought that he might. Thank you, Brooke, because you, star of this chat today. Zach, thanks for the 5. I'm here to argue and chew gum, and I'm all out of arguments. Wait, did I get that correct? Lori, thank you for tuning in from Canada. And the super chat, double the query, double the fun, double it, double income. I remember that commercial. It's 12:48 p.m. here on the East Coast. We know that the judge has other cases to hear at 2 p.m. So they're at sidebar right now. They may just break until tomorrow because she said this was going to be a short day. My information, I have information that she's one of only two judges hearing criminal cases in Norfolk County this week or this month or these days. And so therefore she has other calendars she needs to attend to. Nancy says Dedrick, this medical examiner, made a cool $306,400 last year. How much did she make on the side for this case? Inquiring minds, Nancy, but I guess that's public information. Over $300K she made as a medical examiner in Norfolk County. Jason Smith, this is such a great reference. Does anybody in here remember the Jerky Boys? I do. I had a cassette tape with the Jerky Boys on it. It was like a cassette tape of phony phone calls. And yeah, they would make phony phone calls. And the guy said, I was hurt at work today. He hurt me with his words. Whoever thought that craziness would become reality? Remember when he said, I fell down the stairs and my shoes came off? Freeloader Woodchuck said the hormones are in his body. His body should have maintained calm fight or flight. His inability to ground himself and control his anxiety and anger is not her fault. I agree with you. Happen to agree. Judy says people of Massachusetts never interact with other people. Holly, thanks for the super chat. So if the Emmy has a heart attack right now and dies, Judge Bev will have to charge the attorney with homicide/manslaughter because they're having an altercation. I think part of the argument has to be that she knew that he had these medical conditions, which this medical examiner is not testifying to that. She's just saying that in her medical opinion, she is able to determine the decedent's perception that he was in fear. Because maybe she speaks to the dead. I'm not really sure. Curious Liz, thanks for the 5. This whole situation disgusts me. She's essentially saying Penny is responsible for ex-husband's emotions, right? Absolutely disgusting and such a reach. She even said that she did. She does remember reading the police report in which Penny's statement was that he was dragging her around by the hair and slamming her up against the walls and against the stove, and that wouldn't change her opinion. In her opinion, this is still a homicide because Penny McGee was in the room. No, you can't make this up. No, you can't. You absolutely can't, because we're listening to it in real time. My nurse Cal, thanks for the 10. How in the world is anybody responsible for another person's actions or emotions and lifestyle choices? It's the police's job to judge intent. Her job is what factor ended life. Yes. We're back. Thank you.
All right.
Thank you, Mad World. Super chat.
So, Mr. Tipton, are you done for purposes of today, and then we'll do redirect tomorrow?
I was hoping to be able to suspend for these 10 minutes so I can talk to my expert.
Yes, we can definitely suspend, but okay, so that's all I'm wondering. So you're not done.
I'm not.
Okay. Doctor, we need you back here tomorrow morning.
Okay.
All right, we'll see you. We expect that you will be finished tomorrow.
Okay.
All right, tomorrow morning.
Okay.
All right. All right, thank you very much. So you can step down, doctor.
Some of these are yours. I'm going to leave all of that there.
Great, thank you. And Mr. Tipton, I think you've got an identification or
This is all
the 2018 article maybe, or you've got.
I've got a marked in an ID.
Okay, thank you.
And I will return that because I have a.
Okay, thank you. All right, so doctor, we'll see you tomorrow morning. I'll see everybody tomorrow, and tomorrow we'll also address the statement of the witness. All right, thank you, everyone.
All rise, please.
All rise, please. God save the Commonwealth.
Do you have a minute, Judy?
God save the Commonwealth. We're coming back tomorrow. the continuation of the cross. But look what I found, thanks to you guys. Court TV, they're on a delay, a big delay. But you wanted to get a look at Rebecca Dedrick, who we just heard testify. So we're going to do that now. And you can tell me if she is what you imagined her to be as you were listening to her testimony. They're still on direct here, but let's see if I can get this to work.
I had 2 sets of Beth Israel records.
Did you see anything in the medical record from Beth that was consistent with an increase of hormones in Mr. Savitz?
Could you ask that in a different way? I'm not sure what you mean.
Was there anything in the medical records that you saw that indicated a response to an exciting event that we were just discussing? Anything like a flood of hormones, an increased heart rate, or high blood pressure?
Oh, I'm sorry, I misunderstood. Yes.
What was it?
If you're not looking at your screen, you can come back and look at your screen so that you can see the witness. This is Rebecca Dedrick, forensic pathologist who wants the judge to believe, because there's no jury here, homicide by argument is a thing. According to her.
So 2 separate pieces. One was the description that the decedent had been in ventricular fibrillation, then he became asystolic, which means that his heart essentially stopped. There was then a return of spontaneous circulation, also known as ROSC, and then he went into ventricular fibrillation again, and then ultimately was asystolic, no longer had a heart rate. So that is one piece. He had differing rhythms. The other piece was that an EKG was performed, an electrocardiogram was performed, indicating an acute myocardial infarction.
All right, hitting the pause button on that testimony from the forensic pathologist. We'll have more from this
And
Socialite
that
manslaughter.
is Rebecca Dedrick, the doctor, the medical examiner extraordinaire, who, in my opinion, has lost all credibility as an expert witness forever and ever and ever in the state of Massachusetts. Let's go to the chat. We're going to come back tomorrow. We're going to finish tomorrow. They're going to finish cross on this witness, then a redirect, and then there is an expert coming in for the defense. So there's that. Let's go to the chat. Everyone smash the like button, because this has been quite a day. My goodness. Dr. Russell is the GOAT, coming in from Norway, says this is victim blaming times. Rehab Department Group says, OMG, this Dr. Rebecca Dedrick works across the street from me. That's crazy. On top, thank you for your super sticker. King of the Rico says no one witnessed John's death, so how was his death ruled a homicide? Well, remember, John O'Keefe's death, manner of death was never ruled a homicide. It was undetermined by the medical examiner. They tried to strong arm her into changing it, Dr. Irene Scordi-Bello, but she wouldn't. And yet they still charged Karen Reed with murder, even though the medical examiner in the Karen Reed case did not call his death a homicide. She called it undetermined. My nurse Cal, why daughter night in court being blamed? I don't know. Is she there? I don't know. I don't know if she's there, and I don't know if she had an altercation with him. I don't know what I mean. A Gatling gun, a dystopian approach. Has she ever heard that correlation doesn't equal causation? I have no idea. Thanks for the super chat. WTF, Massachusetts. What the duck? This is ridiculous, says Virginia, who's been here for 10 months. Mad World says, should have saved this trial for April Fool's Day. But no, because that is the Karen Reed's trial. The Karen Reed trial is going to be on April Fool's Day. TCP, thanks for tuning in for the super chat. I'm catching up and wondering if the lawyer dies of frustration with the medical examiner, is she guilty of homicide? That's a great point. I got to know. Thanks for the deuce. I'm so angry. Cleaned the whole house and 4 dog baths. Thank you, Goodmans, for gifting a membership. Love you guys so much. Melanie, I sent you an email about a case. Thank you, Susan. I can't break in the middle of this to read it, but I always read my emails. I don't always get a chance to respond to them, but thanks for giving me the heads up on that. I bid him. Chloe, thank you for the super sticker very much. John Beatabot says, watch football. Ref makes a bad call, triggers a heart attack, equals murder. Well, Today, we heard this Dr. Rebecca Dedrick, the medical examiner, testify about homicide by argument, and it didn't matter to her. Penny McGee may have been defending herself against a guy who was dragging her by the hair and slamming her up against the wall. Didn't matter. She still thought, in her determination as a medical examiner, this was a homicide because there was another person in the room. She was asked about another case where there was a robbery and the robber fled, and it could not be ruled a homicide because, according to her, there was no other person in the room. Are we really living in 2025? We are. Are we really in Norfolk County? Yes, 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 we are. Are we in the judge room of Judge Beverly Cannone? Absolutely. And has this defendant really opted for a bench trial? And she's going to let the judge decide whether she's guilty of manslaughter and deserves 20 years in prison? Yes, she did, because apparently she must have seen the Karen Reed trial and she is afraid of juries. And I don't know that I can really blame her. Can you? Thank you, Barbara Dulong, for your $20 super sticker. You are so kind and generous, as always. Thoughts, comments, questions, concerns before you wrap for the day, and then come back tomorrow to cover this case live again. I think they have court also on Wednesday. And then, of course, we have a Karen Reed hearing on Thursday. So there's going to be that. Thank you, Karen, for becoming a new member. Al says, I don't think Bev's going to agree with the medical examiner. I don't know. I listen, I really don't know. I would spin a wheel and leave my fate in the hands of Judge Cannone. I don't know. What do you got? What say you? Olivia says, excellent point. What's Olivia's point? Me Merity says this really is a case for a judge because it comes down to one very particular legal issue of intent. Yes. He can ask for a directed verdict at the end of the close of the prosecution's case. And I assume that he will do that. I'm so happy that he got our information, our telepathic information, on looking at page 22 of those guidelines for medical examiners. So if you guys are interested in watching the rest of the testimony, you can watch it because it's delayed, but you have to go to courttv.com and suffer through the commercials and the commentary instead of hanging out with me. But you may do that. Court is over for today. It's over for today because Judge Cannone has an afternoon calendar and other cases to handle. So there's that. We will be back tomorrow at 9 a.m. Today we had to suffer through the Zoom with audio only, but it was fascinating. It was still fascinating. We had good audio. We got to listen to it. Court TV decided to cover it apparently at some point, but it's on a severe delay. So we wanted to listen to it in real time. And this was insane. All right, moderators, thanks for keeping the chat classy today, because this is not always an easy county to cover. I think we have to now extend it to the county. Thank you, viewers, replay viewers, channel members, all of you. Love you all so very much. I love you with all of my heart. If I don't see you soon, I'm not gonna die. Yeah, this is a great stream to just listen to with earbuds or while you're driving, because you don't have to watch the screen for this. So there's that. Thank you, Mrs. Bucket, who says, love your passion for getting justice for all. If any of you planning on going tomorrow to court, I think it's going to be a full day tomorrow. What everybody's saying? Wow, Olivia, what is it? What is it? What is it? I can't scroll back to find out what Olivia's talking about. If any of you are going to go, be boots on the ground in Norfolk County in the courtroom, let me know, because you can call in and tell us your thoughts and observations. Didn't look like there were a lot of people in the courtroom today. So there's that. Oh, here. Thank you, Olivia. Why didn't Michael Marcy press charges against the two who fought a Patriots fan at the game last year, causing a heart attack and death? Marcy said he must have had health issues. Sorry for the repeat. No, thank you, because I wouldn't have found it. I'm glad you did. That's wild. I don't know that case, but yeah, it makes you wonder, did Andrew Saviitz have political connections? And that is why they are following through with this persecution of Penny McGee. I don't know. Somebody make some signs. Free Penny McGee. She needs some support. Penny McGee, if you're watching this at some point tonight, we support you. We are hoping that you are let out of this nightmare relatively soon. You've been living this for 5 years. The fact that they actually indicted you on manslaughter charges and you were looking at 20 years in jail, frightens the bejesus out of every single one of us, because you, like Karen Reed, could be any one of us. Having a verbal altercation with your ex-husband because he's evicting you from your home, or his brothers are, and he drops dead of a heart attack because of all of his comorbidities and his horrible, horrible health. We don't think it was your fault. We don't think you ever should have been charged or indicted or have had to go through this nightmare scenario for the past 5 years. 5 years now. Free Penny McGee. Thank you guys. As I always say to close every stream, stay cool, stay kind, stay classy. It is not hard. I promise you, it is so not hard. Make sure you smash the subscribe button and make sure you are set to all notifications, because yesterday I went through my subscriptions. I subscribe to a lot of channels. And as I was going through them, I'm like, why am I not getting notifications? It's because I didn't have them all set. You also have to have them set, or sometimes YouTube changes it on you and you don't even know. You could be unsubscribed and you don't even know. And you got to make sure your phone, you enable notifications on your phone so that you actually get them. Who knows if something could pop today on Karen Reed? If it does, I'm going to come back and do it. That's why you want your bell set. Stay cool, stay kind, stay classy. You can do it. I know you can. I know you can. Peace, my friends. If something happens today on Karen Reed, we're coming back for it. So see you later.